human intelligence. It is like creation of minds. Creation of minds. Some of the simple examples like new logo, any new name, slogan, images, or any traditional knowledge, any product, any process. If anyone knowing any new process of making tea, coffee, any medicine, or any other things, you can file for that intellectual property. Then any literary or artistic work, the edibles, articles, then from geographical origin, like GI tag, geographical indication tags. So that products also comes under intellectual property. Similarly, different shapes, patterns, designs, that all comes under creation of mind. These all are the creation of minds. And that for creation of minds, you can get uh, incentives as a intellectual property if you register that under that particular act or rule from the government organization. This is the umbrella of IPR. Under this umbrella, there are some important IP rights mentioned. One is patents, design, then geographical indication, copyrights, trademarks, semiconductor integrated circuit layout designs. So we'll discuss this all IP rights in our next session one by one. Now, what is intellectual property? Intellectual property is a term, means it is giving exclusive rights and recognition or recognize to that particular creator for his IP, specialized IP. It may be patents, in the form of patents, in the form of trademark, in the form of copyright, in the form of geographical indication. You are getting exclusive rights. So if you're having that rights, you can make replicate that, you can show public display, you can sell or you can assign that rights, and in exchange you can get monetary benefits. Now in this intellectual property rights, from the time when we wake up in morning to till sleep, we are surrounded by different IPs. The morning alarm clock is one type of IP. Then tea, you having tea or coffee. Then sandwich or breakfast. So making of that sandwich or breakfast, that process or the machine you are using, that's also falling under any of IP. Similarly, your clothes, that's also having different IP. So we'll discuss this all thing one by one in next slides. Intellectual property rights. So basic funda is that if you have any new thing in your mind or any new project you got from your colleague, your friends, or anyone, you start to think about that topic. Means your brain activated that time towards that specific topic. Then your brain start to make a framework related to that. In that framework, it is making some rough drawing about your topic or project. Then you start to think about resources. Resources like available material, any books, any references, standard references, help from professors, project guides, and internet. So that comes as a resources. And third, labor activity. Means you are combining that your brain, resources, and actual working on it gives you your project. This is same applicable for intellectual property, any intellectual property. If you have any poem, simple example, poem or story, you start to think about that. Then just by getting some more references, you are compiling that in proper word, or you can get paper pen, that also comes as resources in this case. And finally you are noting down and publishing somewhere or showing somewhere, that makes intellectual property, because poem story is also part of intellectual property under copyright. Now what is the importance and significance of these IP rights? You can protect your rights for your own self. If I have any IP rights with me, I can protect that for myself. Also, I can exclude others not to use that without my permission. Also, I can utilize that for commercial earning purposes. So these three points are very important in it is telling about the importance of your IP rights. Now, how can you utilize these IP rights? Firstly, you can use for your own self. You can start your own manufacturing production and you can use for only one single person or for your family. Second, you can give license or assign rights to the person who are interested in similar business or similar field. Another example is franchisee. You can give franchisee to other person. Example, McDonald, Pizza Hut, Evolati. The owner of these all brands, they are not coming, the owner is not coming and starting his branches. He's just giving franchises to the person who are interested in similar business. And another option is merchandise. Example is Disney. So you can use this four or some other options to utilize your IP rights, and in exchange of that you can earn money from that. Now if you have IP rights with you, now there is a two type of perspective. First is common person perspective and second is businessman perspective. Common person, yeah, I got patent, trademark or any IP rights, feeling pride. I am showing to my professor, my colleagues, my students, putting post on any social media platform, also taking printout, putting on wall. If possible, I can use that for my academic purpose or getting a good salary, good hike or project purpose. That's it. Common person stops their work after getting IP rights. But businessman thinks differently. Once they get any IP right, they start to commercialize that product. Once any product starts commercialization, they are not stopping there. They making that product as a brand value. They doing marketing, more research, then public awareness about that product. Once any product gets a brand name, brand value, that product gets more revenue from that. So their earning goes increasing, and from that earn money they again take some part and do a new research, new inventive concept, new idea. From that new idea, new IP right, again new IP right, new commercialization, new brand value, and that process continuously goes on. So you should think like a businessman if you having any IP rights with you. So we'll start with our first IP right, that is a patents. Patent is a monopoly rights, exclusive rights given by sovereign authority. In our country, only government of India is a sovereign authority. No private organization can give you these rights. In patents, you have to give a disclosure of your complete specification, because the term for patent is 20 years. After 20 years, it goes in public domain. So you should give such a disclosure that it can be re constructed after 20 years by the person skilled in the art by just reading your data. These patent rights are territorial in nature. Means if you're having IP rights or patent rights in India, you can utilize or enjoy that monopoly rights in the boundary of India only. If you want to get IP right, patent rights in USA, China, Japan, you have to file separate application in that particular countries. These are the famous Indian inventions. Nano car. Tata provided an opportunity to middle class people to get a four-wheeler car in the budget of two-wheeler bike only. This is a really good invention. Then hepatitis vaccines, Jaipur fort. This Jaipur fort cost in India around 3 to 4 thousand rupees. But similar Jaipur fort cost in USA around 7 to 8 lakh rupees. So we are fortunate that there are many inventors who are making our life easier. Some other example, this is a baby shower cap. सभी को पता है छोटे बच्चों के आंखों में पानी आ जाता, जब नहलाते हैं तो पानी जाने के बाद दे गेट्स इरिटेटेड. Inventor uses creative mind. Instead of normal cap shape, he made a zigzag like structure on cap, and that's giving solution. You all are aware about projector. This is a wristband projector. You all are aware about normal projector, the cinema hall projector, auditorium projector. But this wristband projector, you can project on your nearby place, palm or any notebook nearby area. So you can do that without any much hurdle. Then this is a micro card reader. You can directly connect to your phone or the person who is receiving money, his phone directly, and do a transaction. Then drone system. You all knowing that drone is using for video purpose, photography purpose. Farmers using for spraying pesticides. Defense purpose also you are aware. You have seen some movies like Uri where they have shown the use of drone for defense purpose. The current version of new drone is can carry one person from one place to another place, and which having capability of around 100 kg to carry that. Also some e-commerce company like Amazon, Flipkart, they using drone for goods delivery purposes. Now this drone is not stopped here. In drone itself there is another thing is anti-drone system also started. So technology continuously changing. This is Wright brothers flying machine. This is patented in 1906. This is Graham Bell's speaking telephone. It is patented in 1881. This is Thomas Edison's light bulb, 1879. These all by the famous scientist. Also, uh, you all know Abraham Lincoln. He also filed one patent in USA in 1849. Then the telescope we were using, that is patented by NASA in 1906. Now this is the simple and interesting invention. Due to the lack of space in our country, because due to population it is little bit difficult to accommodate all people and to adjust in small area houses. So and we are using many electronic gadgets, so many chargers, connectors, cables, and that all gets mixed with each other. So to sort out that, this person uses creative mind and make a just cord separator, and this is simple but giving solution. Bendable power strip, as per your required or as per available of space in your home or your table, it can bend and it can give solution. Similarly, there is, as I have told, some examples or some improvement in drone. Same for SIM cards. Earlier we are used to this mini SIM card, then micro, nano, now eSIM card also there. This is communication evolution. Earlier phone, then telephone, cordless, mobile phone, smartphone, smartwatches. So in each field, there is continuously improvement going, and for that each improvement, they are filing for patents. Till now, we discuss all things which are patentable or the things were patented one. Now we'll look some things which are non-patentable. If anyone is claiming any frivolous thing, like from Dr. Ambedkar University to Mumbai, someone reaching by 1 second or 2 second, practically and today that is not possible. Such frivolous things are non-patentable. If anyone claiming any natural or scientific theory, that is also non-patentable. Any scientific principle, any abstract theory, or discovery of living things or non-living substance occurring in nature, which is natural thing, you can't claim that as a patent. Mere arrangement and rearrangement of two things or four things together, but which are not at all interlinked with them, such things are non-patentable. Method of agriculture, method of horticulture, that is also non-patentable. Method of treatment on human or animal, that is also non-patentable. Computer program or computer algorithm is non-patentable in India. It should be have some hardware support with it. In this picture, this person's name is George Alfred Depenning. He's the first person who received patent in India. He received patent in 1856. Means before the rise of Mangal Pandey, that is 1857, he got patent in India. Means India also having very long history about patents. He was civil engineer and his invention was an efficient pankha pulling machine. But now you will think that for getting patent, we should have the big machine, big scientific data, then only you can get patent. If you have big scientific data, big research, that is a well and good thing. But if you have solution to a particular problem, then also you can get patent, because this is a simple paperclip. This is patented in 1990, means at the time of First World War. The inventor used his creative mind and made a simple wire in a special way that it can hold a set of paper, and that is giving solution. If you have solution to a particular problem, then also you can get a patent. You all are knowing this is a Michael Jackson. This Michael Jackson's shoes was patented, and he was himself the inventor for that. To do that anti-gravity move, he made a special structure on his groove of that shoes, due to which he can bend in 45 degree. And he received patent from USA in 1993. Now for patents, to get any patent, it should fulfill three criteria. First is novelty, second is inventive step, third is industrial application. Now what is novelty? Novelty means completely new, not known to anyone. Now what is the purpose? The novelty means they no one knows the existing knowledge about that things. It is completely new, completely novel. Or in that case, novelty can be defined based on two factors. First is technical aspects and another is legal aspects. So you have to judge, is it falling under these two technical aspects or uh, legal aspects. Novelty is a new thing implemented in already existing subject matter, which like prior art. But novelty is a part of legal test to determine whether it is an invention is patentable or not. Now, the criteria for patentability is section 21J, that is invention. And invention means a new product or process involving an inventive step and capable having industrial application. So, as per this section 21J, your invention should be fulfill these three criteria: novelty, inventive step, and industrial application. Now, what is inventive step? We discuss about novelty. Now, inventive step. Inventive step means it should be differ from prior art and which focus on the extent or degree of differences. The difference is obvious for person skilled in the art from the respective field. That step, inventive step, that step means the minor improvement also you can consider, but that is not obvious. It should suggest a significant advancement in the technology. uh, IA, that is industrial application. So it is a very much essential criteria because example, if anyone is making atom bomb, which is not useful for mass people, but similarly if anyone is making any vaccine, that is a useful for mass people or mass industry. So your invention should fulfill or useful for more people. If it is useful for only one or two people, then you can't claim that it is useful for mass industry. So whatever your invention is, it should fulfill these three criteria, that is novelty, inventive step, and industrial use. In industrial use, it should be practical application and economic significance also they are checking. Now, point is, if you're having some idea or concept in your mind and you want to know that is it already patented by someone or not, in that case you can search that similar subject matter on this some databases available. I'm just giving example of free databases, that is a INPAS, that is Indian Patent Office searching platform, then WIPO Patent Scope, eSpaceNet by European Searching Authority, and patents.google, where you can use different keywords and search the similar subject matter, and based on that you can decide to go ahead. Next IP right is design or industrial design. Design or industrial design patent or industrial design, it is any ornamental or aesthetic aspects of an article in which features like shape, configuration, patterns, ornament, or composition of lines, colors, which applied on any article, and it is made by any industrial process. The process or the material which is used, that doesn't matter in this case, and you are judged solely by your eyes. If you are identify these two designs separately, then that falls under design patent. The term for design patent is 10 years and you can renew for more 5 years. Suppose you have pen, these two pens, each having different design, different structure. In market, if you go for taking a water bottle or drinking mineral water bottle, you can find different design, different shapes bottle. The reason is that each company is trying to keep their design as unique as compared to their competitor. Similarly, in your auditorium itself, there are two, three different types of chairs available. So that chairs are falls under design, having different designs. Everyone using mobile phone, laptops, they're having their unique design. The relatable features of shape, configuration, it is article by industrial process. And this all should be appealable to your own eyes. different shapes, chairs, many products coming in Tetra packs nowadays. So these all company trying to keep their Tetra packs as unique as compared to their competitor. Different shapes, bikes. This Coca-Cola bottle they have filed under design patent. Similarly, that glass also they filed under design patent. So no other competitor can make same bottle as Coca-Cola. This is the perfect design because this pin, safety pin, in 1849 was also same design, 1911 also to 2025. This is the perfect design structure. Now, if you're having more than one product which having similar design, like jewelry set, crockery set, knife set, sofa set, so in that case, you can file for set of design product. It means the number of articles with same general character. You can file for in that category set of design. These all are pencils. The use is just pencil work, but each one having their unique design, unique shape, unique structure. So this also falls under you can file for design patent or industrial design. Different shape toys, different shapes ornaments, lines, combination of colors, toys, different shapes of glasses. The material what you are using or that doesn't matter in design aspects. You have to be unique design. That's it. The only criteria you can which is judged by eyes or which is applicable to your eyes. Trademarks. Next IP right is trademarks. So sign and a symbol which is capable of distinguishing goods and services from one enterprise to another that comes as a trademark. Here this arrow symbol, it is Nike. Then this is Adidas. This is Puma, McDonald, Pizza Hut, Domino's, FedEx, Indian Post, Hindustan Unilever, Apple, TCS, Z, Flipkart, Amazon. So have you noticed I have purposefully removed their names? Still, just by seeing this logo, you are able to identify these products. The reason is that they having their unique trademarks. That is the power of that trademark. Now, what comes under this trademark? It can be a brand name and tagline. Example, Coca-Cola, open happiness. So, Coca-Cola is a brand name and tagline, open happiness. Similarly, LG, life's good. Nike, just do it. Here is a brand name, this is a logo, symbol, and the tagline. These all three together makes a trademark. Some certification marks like BIS mark, ISO mark that may be a part of that trademark. Sound marks. Many people using iPhone, so the ringtone of iPhone is unique one. The reason they have taken trademark for that. Then IPL ringtone. Similarly, Britannia's ting 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 ding. Just by listening this, you are able to identify that product. That is power of that trademark. So trademark is a sign and symbol which is capable of distinguishing goods and services from one enterprise to another. But after 10 years, you can renew it for indefinite time. So in this, how can you identify this product having registered trademark or not? So R in circle means that product having registered trademark, and TM mention means they have filed for registration but yet not finalized. Next IP right is copyright. Copyright is a legal right, and uh, le- uh, this legal rights given for your artistic work. The artistic works can be literary work, musical work, then artistic work, cinematographic films, sound recordings, computer program. For this category, you can file for copyright. In literary work, it can be any table, any study material, any notes, any poem, story, news article, that all comes under literary work. And musical work like music, lyrics, that comes under musical work. Paintings, poster, drawing, photography, then movies, drama, audio visuals, uh, singing, song, dance steps, computer program algorithms, that also comes under this copyright category. If you want to protect that specific thing, you can file for copyright. How can you identify this product having registered or copyright or not? So C in circle means that product having registered copyright. Copyright is a legal term describing the rights given to creator for his literary and artistic work. So these rights given to creator for his artistic work, but which can be expressed by the person. Without expressing, you can't get. Copyright is a bundle of rights. It is automatic right and exclusive rights. It is given to creator for its original work. Copyright cannot protect an idea. Means suppose Sachin having one concept of one story, that is ABCD is a character, PQRST is sub character, and so on. Similar story Virat also got in his mind, but Sachin's kept that idea in his mind only. Virat note down that ABC character, PQR sub character, he framed that story and he note down and he shows to Rohit or some any of his friend, or he just note down. So first rights given to Virat, though Sachin having similar story concept in his mind earlier, but who expressed that firstly? Virat expressed. So Virat having that rights to enjoy, because copyright is an expression of an idea. If you are expressing, then only you can get that rights. Copyright is an exclusive legal rights granted to creator for his expression of idea. Copyright owner can reproduce, translate, adapt, perform public display of his work. Registration of copyright is not mandatory, but for legal enforceability, it is more recommended that you should register your work under copyright. Example, uh, some years back there was a movie name called Fan by Shah Rukh Khan. So in that movie, one writer claimed that that movie is based on his novel, but legally he was unable to prove. That's why it is recommended to you that if you have any articles or anything which falling under this copyright category, you should get registered under copyright. These are the sections where you can get copyright. That is literary work, paintings, photography, drawings, films, music, choreography, sculpture. That all comes under copyright. Now, what are the terms for these all different parts of copyrights? For literary and literary work, or I am the author of any book, so I will enjoy that copyright for that book for whole my lifetime. After my death, my legal hire will enjoy more 60 years. For drawings, paintings, photography, the term is 60 years from the date of first publishing. Similarly, for movies, songs, same applicable. There is a one case study related to copyright. There is a wildlife photographer, David Slater. Uh, he went to one jungle and he forgot his phone, or he purposefully kept one monkey, this black ape. came and he took selfie from that phone. Due to Google backup, he received that photo. Then this Wikimedia magazine published that and earned some money from that. So there actually quarrel started between David Slater and Wikimedia. So David Slater said that photo captured by using my phone. So the copyright is with me. Wikimedia said the photo clicked by ape, so the copyright is with that monkey. Finally, PETA, the Animal Welfare Association, came in picture. They also claim that it is captured or money generated by using this monkey. The copyright should be or the money should be given to PETA. Then US court gave a landmark judgment saying that copyright cannot be granted to any animal. The copyright is given to only human. And by that money earned by this photo, they ask them to use for the welfare of animals. Now next is broadcasters right. Who is a broadcaster? Like example, Kapil Sharma shows. The Kapil Sharma's broadcasting rights is with Sony TV. So only Sony TV can broadcast that show n number of time as per their wish, as per their choice. Similarly, Z Saregama, they can telecast that Saregama program n number of time because they're having broadcasting rights. Similarly, Z Little Champs, CID, you are seeing many times, or some movies also they took their broadcasting rights. So the reason behind that, the broadcaster rights with that specific company or production channels, so they can use that. The term for broadcasters rights is 25 years. Performers rights, who are performers like actor, juggler, singer, musician, dancer, puppet show, those who are doing some different performance, that falls under performers rights. The term for performance rights is 50 years from the date of first act. Next, IP right is geographical indication. So geographical indication is a tag given on a product which having special quality due to local environmental condition and local labor skills. Example, our own Kokon Hapus. In market now mango season will start. People used to ask Kokon Alfonso. No one is asking Patil Hapus or More Hapus or like that. People asking Ratnagiri Hapus or Kokon Hapus because that Hapus Alfonso having a GI tag on it. Similarly, Mahabaleshwar strawberry, Ratnagiri kokum, Vengurla cashew, Alibag white onion, Pain Ganpati idol, which this example are from Konkan region only. Also some other example like Tejpur lychee, Chanderi fabric. Everyone, almost all people drinking tea, and no one asking which brand tea. They are saying Assam tea. In advertise also, we have pure Assam tea or pure Darjeeling tea. The reason is that the Darjeeling tea is the first registered GI in India. There are more than 300 products which having special tag, that is a GI, geographical indication in India. Solapur chadar, Solapur towel, Puneri pagdi, Nashik grapes, Jalgaon banana, Paithani sari, Banarsi sari, Mahabaleshwar strawberry, Warli paintings, Kolhapur jaggery, Kolhapuri chappal, Nagpur orange, Ratnagiri kokum, Sindhudurga kokum. So these are the famous and some examples from Maharashtra. Then Lasalgaon onion, Vengurla cashew, Wagya घेवडा, Mangalveda jawar, Sangli resin, Beed custard apple, Jalgaon brinjal bharit, Solapur pomegranate, Marathwada kesar mango. Next IP right is uh, regarding GI. GI tag is not given to individual. It is given for the community or the people who are working on similar stage. Because Ratnagiri Hapus is given for that whole region, Konkan Hapus. It is not for one single person. So the people who are cultivating or making mango productions, these all people will get benefit from that. Next is SICLD, that is Semiconductor Integrated Circuit Layout Design. The internal, everyone using mobile phone or laptop or any electronic gadget. So in that there are internal PCB structure is there. If you having that internal circuit layout design as unique design, so you can file for that under SICLD, and the term for SICLD is 10 years. Your design should be distinctive and distinguishing from the registered layout design. Another one more IP right is there, but which you can't register. That is a trade secret. You are keeping that recipe or the process or formulation secret, not disclosing to anyone. Example: Coca-Cola's recipe. The recipe of making Coca-Cola, the taste or specifically taste, they kept as a trade secret. They have not disclosed to anyone. So similarly, Big Mac sauce from McDonald's, they kept this recipe as a trade secret. If you want to get more information or filing related to this thing, you can visit this ipindia.nic.in, where you can get details about patents, design, trademarks, and geographical indication. For copyright, you can visit copyright.gov.in. Now, in this picture, you can find a single product, that is a Apple MacBook, but they having multiple IP rights in it. First, logo, that is sign, that is false registered under trademark. Then this LED display is patented one. The body shape or design is registered under industrial design. The user manual of this MacBook, they have registered under copyright, and internal layout structure is registered under SICL. So one product with multiple IP rights, that's the reason they are enjoying monopoly. So if you're having IP rights, you should do similar way. Now we'll look some patent filing procedure. If you want to file application in India, there are some 4 to 5 mandatory forms are there. First is Form 1. Form 1 having the details of application and applicant. Form 2 is for details of invention. In that details like title, background of invention, drawings, brief description, abstract, drawing description, claims, that all comes under Form 2. Then next form is Form 3, that is details of foreign filing. If you are filing in India or outside India, that details comes under Form 3. Form 5 is for details of declaration of inventorship. And Form 18, that is one of the important form, that is request for examination. If you want to get proceed of examination and further process, you have to submit Form 18 within mentioned timeline. Now, what is the fee if you are filing as a natural person or startup or small entity or education institute? The fees is around 1600 for natural person, and for if you are filing as a company, it is around 8000 rupees. Fees may vary based on number of pages and number of claims. This is general fee for 10 claims and 30 pages. This is a fixed fees. For plus addition of each number of page and each number of claim, the fees get increased. Now there is a two way you can file your patent application. One is offline and online. For offline, you have to take the printout that completely fill form and take printout and submit to nearby patent office. In your case, Mumbai Patent Office is the nearest one. There are four patent offices right now in India: Mumbai Patent Office, Delhi Patent Office, Chennai Patent Office, and Kolkata Patent Office. You can submit your hard copy and do a payment. You will get the application number, and you can track that by using that number. Another and easiest way is online filing. This link is showing the for the online filing purpose. After going through that link, you will go on this screen. Here, after entering, just do a registration, new user sign up. You will by entering credentials, that is login, password, and all things. You will go ahead. You can upload that mentioned form. That is form 1, form 2, form 3, form 5, and form 18. These five forms are mandatory one. These five forms are mandatory. There are many forms, but these five are the must. You have to submit this. Now government, earlier you may heard that for patent it is getting too lengthy process, too much time required and like that. So government comes with new initiative, that is expedited examination. If you are falling under the startup, small entity, or one of the applicant as a female, as a joint applicant, or any government registered organ, establishment, government funded education institute, completely government funded, or any, if you are choose India as a ISA or IPA as a category in PCT, in such cases you are eligible to file for expedited examination. In this expedited examination, the process start and finish around less than 3 years, or before that. I know some cases which finish around less than 2 year also, but I'm on an average I'm saying 3 years. So you should get benefit from this. Now what happened in examination process? Once you submit your application in online mode or offline mode, in online, one more advantage of online filing is that you are getting around 5 to 10% fee reduction, because government also promoting for e-filing and online payment. So you are getting some that fee reduction in that also. 5 to 10% reduction is there. In after you are submitting your application, it goes for screening and classification purpose. In screening and classification, first they are checking, is it falling under atomic energy or defense. If it is falling under atomic and defense, they are sending that application to that particular department, that is uh, Baba Atomic Energy Research Center and DRDO, to check is it falling under related to you, or you want to continue with this application. The remaining application, it processing and checking their subject matter. That is, it is related to chemistry, biotech, physics, mechanical, electrical, civil, biomedical, pharma. So based on that subject matter, it is classified. Because in patent office there is almost 12 to 14 different branches, examiner and controllers are there. So based on that subject matter only, that cases are allotted to them. After that classification, it's publication. Publication means grant or refusal, not like that. You should not think like my application published means I got patent. No. After publication, your actual examination process starts. In that examination process, similar subject matter or subject branch wise, that case allotted to particular examiner and controller pair. In that examination process, examiner and controller both will go through your invention thoroughly. They will check subject matter legally and technically. They will read and understand your invention with comparing drawings and claims. then they will search similar subject matter is available in worldwide database. We have access of worldwide databases. Then we'll check about novelty, inventive step, and industrial use. As I have told in initial slide, that three criteria: novelty, inventive step, and industrial use. So based on that, they will prepare a report about your uh, application. That is the first examination report. That reports sent to you by controller for whatever the objection they raise. You have 6 months time to reply that FER, first examination report. So in examination, uh, then in 6 month time you can answer whatever objection raised by controller. You again answer them and submit to office. Office examiner will again recheck whatever question objection raised and what is your response. Based on that, the pending objections will be conveyed to applicant again as a hearing notice. As per natural justice, we will give hearing if there is pending objections are there. So based on that hearing and return submissions, that hearing also online mode only nowadays. You not required to visit patent office for attending hearing. You can attend that by using your phone or laptop itself. So by that hearing, controller will ask some technical questions based on your subject matter, and based on your response to hearing in written form and orally, controller will take his decision, because and that will be the grant or refusal decision. So that is the process of patent filing and the basics of all IP rights. So thank you everyone. Thank you for listening calmly. Thank you Baba Saheb Ambedkar University for giving me opportunity on this special IP related program. Thank you Zado madam. Thank you Professor Zado, and thank you Professor Hirve for giving me opportunity. Thank you my family Ridan Pranali for your support. Thank you everyone. If anyone having any doubts, you can ask. Yes. Your voice is not clear actually. Actually, your voice is not clear. Is it possible to write in chat box, or ma'am, you can call and tell. That's also okay for me, because it is not clear what sir is question is not able to understand. Sounds is can be trademark or that's much only I can understand. It's your voice may be cracking actually. Um, can someone type in chat box so I can answer by reading that?
Hello, sir. Hello, can you
Yes,
hear?
yes, yes.
Sir, Dr. Bose is asking, sound comes in both categories, broadcast and copyright.
Okay,
And the broadcaster, you. So in which category that is appropriate?
okay.
Or
Sound. So
which
what
category is playing or the playing.
actually in uh, trademark form just sound like Anil Kapoor recently took that chakas. No one can make that specific dialogue. For complete song or complete lyrics, you have to go for copyright only. It's a small specific like tune is there, then you can go for that. With combination with that logo symbol, then you can that combine thing you can go for trademark. But for only tune or only lyrics, you have to go for copyright. In copyright trademark, that is a name, logo, symbol and sound mark which is associated with that specific logo only, then that falls under trademark. But it is only just poem or only song, then you have to go for copyright.
सर आवाज येतो तुम्हाला आमचा
हो येतोय. Yes.
साऊंडची कॅटेगरी साऊंड कोणीकडे अप्लाय करायचं ट्रेडमार्क कॉपीराइट गोइंग फॉर एज्युकेशन त्यांनी चेक नाही करायचं want to create the sound in trademarks as well as copyrights.
uh, you can file in both categories if you want a combination also and separately also you can do that.
One more question, sir.
Okay.
Good morning, sir.
Hello.
I want to ask the question that what is the basic difference in patent and copyright?
What is the
Difference in patent and copyright.
difference? Patent is for technical thing and copyright is for artistic work. If you have any invention, then you can go for patents like any new machine, new phone, anything you are giving for artistic works means any write up, any study material, any notes prepared by you, any project, which data you don't want, you want to get benefit, or any simple poem, any shero shairi, joke, you can go for that copyright under that all category. For patent, it should be having some technical effect on it and giving some solution to particular problem. As I have given example of paper clip or the mobile phone, any pankha, AC, or the lift that are giving some solution. Some problem is there and they giving solution. For copyright, if you have news article, essay, any good photography, drawings, you can go for copyright in that cases.
One more question. Hello, sir. Sir, if I have registered a patent in India, so you told there is no fee if you want to register in other countries. What is the procedure, sir, actually?
There is no fee.
Yeah,
No, I have
yes.
not said like that. I said if you want to get a protection in different country, you have to give separate application. In India, there is specific fee. For other countries, there as per their patent act. Each country having their separate patent act. So as per Indian Patent Act, I have mentioned some roughly estimated fee structure, that is 1600 plus Form 18 as a 4000. So in India, for individual people is around 5600 to 6000. It is general fees. If you are going USA, they having their different fee structure. So if you are going in that specific country, you can take same subject matter, same as it is. Whatever you have filed, similar thing you have to submit there in their form only, but
So the
fees will.
same design, can I go for register in other countries also? Same patent.
Yeah, you, because you have to just mention that I have priority from India, I have filed in India in 2025, I'm taking that first January 25 priority, and within 1 year you can go to different countries. Or if you are going through PCT, you have 31 months. In that 31 months time, you can visit the place different countries, and you can claim that priority. Means that 1st January 25 is your priority date. From that date onwards, no prior art will be cited against you. So you can claim that priority from here also.
Sir, to that
Yes.
plant extraction, regional plant extraction, regional plant extraction.
Okay, regional plant extension.
How I get
How? Patent, regional plant extraction.
plant extraction? It's the application.
Extraction from plant, you want to say,
And its application.
and its application. So you have to prove that extraction and its use or usability or industrial use, it not known to anyone, it is or not possible. Means there was some cases that turmeric, haldi, we all are knowing that it is used for the skin benefits and all thing. In Europe, they filed as a for treating the fungal things, and they got patented. Then Indian scientists that under TKDL, they gave references from Vedas that this is well known thing from India, well known from Vedas. So you have to mention that it is not at all known to anyone, or from patent office side, they can cite the references from any article from the date of filing, before the date of filing. So if you are saying that any plants extract and using, so you have to mention that this extract, this purpose was not known to anyone. This is new. There was no any reference available earlier. If you are able to easily provide such things or draft such a way, then you can go for that. Similarly, that neem patta, kadulimba leaves. In USA, they filed for something hair treatment or something for wound healing purposes. So it is well known thing in our country. We are using for using uh, for bathing purpose or some antifungal purpose. So that is known thing. They got patent. Even this Dr. Mashelkar and their team opposes that it is not patentable, because as per Indian traditional knowledge, that is under TKDL, we have references from very long time back. They gave citations and they asked them to revoke that patent. So if you're having unique feature or unique extract output, then you can go for that.
One more question, sir.
Yeah, no problem.
Sir, good afternoon.
Afternoon.
Myself, Professor Ravindra Surastai. I want to ask you one question that in Play Store one app is there. The app name is Your Codes.
Okay.
So I have hobby to write something.
Mhm.
If I have taken the subscription of Your Codes, I can publish my poems there. And if somebody took my content from that particular website, they can provide me 80% of royalty.
Okay.
I want to ask you the question that if I have the certain kind of subject notes and I want to publish it somewhere. Means, am I audible?
Yes, yes.
So my my I hope Hendra sir, I am clearly audible.
Yeah, yeah, yes.
So if
Your
I want
question.
that, if I want to make my content, you can say copyrighted without publishing it with the IPR, can it be possible? Any kind of app is there, like your course?
For publishing means whatever I understood is that you uploading your poems or some content on that particular XYZ app. If anyone using that, you are getting around 80% royalty from that, right? So, is there any app or any platform available for without publishing other platform? You
No,
want to
actually,
register or app?
I'm asking you for the tutorial or educational content. So for specific subject, I have made some notes and I want to get it published somewhere. From there, I can get royalty.
Regarding copyright, first things is that you have to whatever your data, story, poem, study material, educational content, you can register under copyright directly. That is simple process and that is also not too costly. You can go that particular website or online or offline, it is easily possible to do that processing. And after registering there under copyright, that rights means from filing itself or noting down itself, it is your right starts there. Now what you are asking, is there any platform available to upload or that? Actually that is a commercial content and I don't think government have started such thing that some apps or companies or organization, they can take the benefit from your original content and they're earning that 20% money or whatever amount like that. But as I know, government is not doing such thing or giving any platform. They're directly giving full platform, that full benefit to you only. They are not taking any extra charges from you for from your revenue. So you have to directly file to copyright office and get full benefit, monopoly on that rights or exclusive rights to you.
So I have one more question. I think parties are the group of mind and comes under credits, that is trademarks, copyrights, GI, and semiconductors, right? However, all are products of minds, right? But after going through your PPTs and the contents and after building our IP in your sites, so what I came to know that these are products of minds and they have their own rights. We have our own ideas, our own rights. But as per the slide shows, he has given the validity of 15 years somewhere. He has given validity of 20 years somewhere, 60 years somewhere, 25 years. All are the rights, all are the same rights. Why is the variation between the why is the variation between each categories of deadlines for the expiring for the expiry date, expiring deadlines for each criteria?
Okay. So for patent term is 20 years. For design it is almost 15 years. For trademark and copyright, you have to initially file and then you can get that indefinite time. For GI, that is geographical indication, initially you are registered for 10 years and you can renew that indefinite time. For SICLD, it is 10 years because after, as I have shown two, three examples, that after each 2 to 4 years, the technology changes. So, and this term and this validity point you are asking, it is actually said by government. It is a policy matter. So I can't comment on this specific point about why 10 years or why 15 years only. But these are the other some the trademark or they have, you can re-register that for indefinite renew, sorry, not re, you can for trademark you can get renew that indefinite time if you're having valid things or valid design like that, valid logo. Similarly for GI also, for GI the criteria is that the product should be made or produced more than 100 years. They having some historical background also required for that. Means from today I started cultivating one species of onion. I'm cultivating for today 10 years, 20 years. I'm also similar to all my village people, but they have don't have any background from previous 50 100 years, then that will not get that GI tag. After 100 years you can get, almost there is some criteria that years, but suddenly it is not possible. And regarding that term, it is a policy things actually, so I should not say anything against that.
Question.
Yes.
Yeah, registered in India. Registration. What is the procedure for that?
Can you repeat what, for which procedure?
International patent.
International patentability.
I heard so that it is a WIPO. So WIPO is there, or is there. Right, we can apply for the international patent. So how to go for that?
Actually, there is no concept like international or global patent. But if you have filed in India and you want to pursue similar subject matter in outside India also, for different countries, Europe, China, Japan, whatever countries, number of things, there are more than one, around 195 or 150 countries are there. So if you file in India and you go to WIPO, that is a WIPO PCT application. If you file in PCT, so you will not get the rights in all countries, but no other countries can patent is granted for similar thing to another person. The rights is with you only. It is the only PCT is there is PCT, WIPO PCT. In that, it is published for WIPO level. So same subject matter is not granted to anyone. That is simple thing. Just I want to say. And for filing WIPO, there is a one option available in IP India site. That is our official Indian website, ipindia.nic.in, in which WIPO is the one section is there, WIPO filing. So by entering details on WIPO filing and their fees and forms, you can go for WIPO and select as a India as a searching authority in that. Yes.
Hello.
Ah,
Pratik sir,
yes.
can you
Yes. Now, okay.
Thank you, sir, for such a fruitful session and making all of us aware about how important IPRs are, how to strengthen the IP60. Thank you for sharing the detailed information about the patents, that is the design patents, trademarks, copyright, broadcast right, patent filing procedure, etc., which will surely help us. Thank you,
Thank
sir.
you. Thank you. Thank you.
Dear participants, the tea has been arranged outside the conference hall. You are invited to join the tea. Then after the tea break, we will start our inaugural ceremony. और पढ़ा तो पर दस बना करिए ಇವ್ರೇ ಮೇಡಮ್ ಇವ್ರೇ ಮೇಡಮ್ टूरनी सर तर सांगा की I think every year for a promotion. आपको अपना Let us now know how the positively as we begin this auspicious event in the lightning of the lamp. May the flame of knowledge illuminate our minds and lead us towards excellence. I declare our dignitaries on the rise to scientific for the lamp lighting schedule. Good afternoon, everyone. It is a great pleasure and honor that we welcome you all to the inaugural ceremony of the Basic Faculty Development Program on Intellectual Property Rights, organized by Department of Information Technology, Dr. Babasaheb This FDP aims to provide valuable insight into intellectual property rights from a state in academia, research, innovation in the field of engineering, pharmacy, and agriculture. Today we have with us distinguished individuals, esteemed speakers, faculty members, and enthusiastic participants. To begin the ceremony, let us extend warm welcome to his esteemed dignitaries on the dais. Honorable Vice Chancellor Colonel Professor Dr. K. Kare sir, who is also chair session for today's event. Respected Registrar, Dr. A.W. Kulekar sir, respected Dean, Dr. S.M. Alwani sir, session experts, Dr. Dr. Manish Kumar Koyekar sir, Dr. Gauri Sharma madam, Dr. Amit Devgir sir. Honoring our esteemed dignitaries is a tradition that reflects our deep respect and gratitude. I request Dr. S. Jadhav sir to present token of honor to Honorable Vice Chancellor for the Professor Dr. K. Kare. Now I request Dr. S. N. Jadhav sir to present Dr. S. N. Nandalwar sir, Dean Academic Dr. Academics and I request Dr. Nishan Sudhar sir to felicitate Dr. E.W. Kulekar sir, Registrar Dr. Babasaheb Computer Technology Institute. Now I, now I request Dr. S.R. Sudhar sir to felicitate our resource person, Dr. Manish Kumar Kolekar sir. Now I request Dr. A.R. Gaukar sir to felicitate Dr. Gaukar. Welcome to felicitate Dr. Amit Devgir sir. Now I request Dr. A.R. Gaukar sir to felicitate Dr. S.S. Yadav sir, our FDP coordinator for his dedication and hard work. Lastly, I request Professor Koena Thakurman to felicitate the co-coordinator of FDP, Professor Sadhna Nuriman, who has worked dedicatedly for this FDP. Thank you, ma'am. Say the context of this FDP, now I invite our FDP coordinator, Dr. S.N. Jadhav sir, to deliver introductory remarks. Respected dignitaries on the dais, Honorable Vice Chancellor, Professor Colonel Professor Dr. Karwari Vishwanath Kare sir, और robot person half more than half of the university. My guide Dr. Sanjay Nambarwar, Dean, Faculty of Engineering and Technology,
HOD of the History Department, then the District Registrar, Arvind Gulekar, and Head for Computer Engineering Department. Resource persons, Dr. Mahesh Kumar Golekar from IIT Patna, Bihar, Professor Gauri Madam, IIT Kharagpur, Professor Devgirkar, Napoli Krishi Vidyapit, IPR से in charge, senior faculty members of the university, HODs, dear participants, and all the persons who are also joining this particular basic FDP from online in online mode. A very warm welcome to all of you to this prestigious basic Atal FDP on intellectual property rights. It is indeed an honor and privilege to stand before you to brief about this FDP in short. This FDP covers the topics such as introduction to IPR, already covered in the first session by Mr. Hendry, Department for Promotion of Industry and Internal Trade, Government of India. Then patent system in India and national biodiversity and similar hands-on sessions, ethical issues related to IPR, patenting in pharmaceutical compositions because major institutions affiliated to university are from pharmaceutical background. The protection of plant varieties and farmers' rights act, copyrights, trademark management in India, with different case studies who are focusing on the practical sessions. Dear participants, I would like to put some important guidelines before the regulatory hearings. Attendance is very compulsory. 100% attendance carries 20% weightage. Assessments is there, MCQs, and these assessment reports we need to send to Atal. They only use certificates to be generated. Article summary to research papers will be given to you, and they will be discussed in the article sessions. The timeline, the schedule, dear friends, is already given by the Atal only. We have to fit our topics in that schedule only. And the topics, articles, research papers already, and the resource persons details, we are already submitted to the Atal portal, and they suggest there should be no alterations. Minimum alteration is the 10 to 50% only permitted due to this and that reason. Some resource persons may not join. Then industrial visit is there, or organization visit is there. Then reflection of journal, whatever research articles we will study, on that you need to prepare a report along with your plan. You have plan, you will be planning to execute at your respective institutions. That plan also we need to submit to the ATA by forming different groups. Dear friends, intellectual property rights serve as the backbone of innovation and research. And through this FDP, we are trying to aim to equip every participant with the basic knowledge and necessary skills, including practical aspects such as searching the existing patents from the different databases, national and international. I encourage all of you to make the most of this opportunity, actively participate and immerse yourself in the sessions ahead. With this, I conclude, and I wish all the best success of the participants to improve their knowledge. Thank you. Thank you.
Thank you, sir, for setting the stage for this enriching journey.
Now I request my guide and team, Dr. Sanjay Narwal, to speak few words on this occasion. Just I request him to focus on the NAP. Already he is having a session on NAP. Glimpse of NAP, maybe 4 or 5 minutes. I request Dr. Sanjay Narwal to speak on the NAP and focusing on the NAP 2020.
Good morning, everyone.
Good morning.
Honorable Vice Chancellor, Professor Karbari Kare, the renowned academician and distinguished historical coordinator of the FDP, Dr. Sivaraj Yadav, all the dignitaries of the dais, all the esteemed registrar, Professor Reddy, all delegates who are present for this FDP, my colleagues, teaching and non-teaching staff of the university. I welcome you all to this beautiful place, Lorraine, and I'm sure that you will enjoy this 1 week FDP on the sense. Really, this FDP is planned very nicely. The speakers which are chosen by the coordinators taking a lot of efforts will be required what we can say experts for the different topics. Definitely, this will be successful for us. Or successful FDP, it will take away so many things from this FDP. I would like to introduce my university. This university is established in the year 1989 as a unitary university, and in the year 2014, government of Maharashtra converted this university into affiliating technological university, and it has been proposed in the academic year or in the year 2016. So this university has become affiliating from 2016, and presently the university is empowered to affiliate the institutes of the Faculty of Pharmacy, Faculty of Engineering and Technology, Faculty of Architecture, and Faculty of HLCD. Presently, university is having about 420 colleges all over the Maharashtra, territory of the university and Maharashtra. And out of these 400 colleges, about 95 colleges, they are main colleges. And for the main colleges, we have implemented national education policy. All initiatives, almost all initiatives of national education policy, they are implemented for university departments as well as all academic institutes which are being under the Faculty of Engineering and Technology. So whatever initiatives like multiple entry, multiple exit, that after 1 year they give UG certificate, after 2 years they give UG diploma, and so on. So all the initiatives which were given in the FDP documents, we started applying those things from the year 2019 to FDP came picture in 2020. So mandatory internship, that is one of the things which we started in 2019. Credit-based system, choice-based system, all these things are in place. In short, I would say that we will enjoy this FDP and encourage so many things to this FDP. Even the university will be enjoyable, I'm sure. We will enjoy this climate. We will visit the nearby beautiful places and hope we will carry good memories of this university. Thank you.
Thank you, sir, for your words introducing our Dr. Babasaheb Ambedkar Technological University. Now I request respected registrar sir, Dr. A.W. Yoginkar, to say a few words on this occasion.
Good morning. I am feeling very privileged and honors when I speak there because I am in company with some of the richest people whose intellectual property is very high. Professor Karbari Kare sir, H index is much more than me, number one sir, Dado sir, my colleague Mahesh Kolekar sir. We all started the career at the same time, and they have garnered so much intellectual property so far. And this is the right combination of people that you have got today to address this. I congratulate especially Shivaji Rao Jadhav and our colleague Yure Madam for organizing this session on faculty development program on intellectual property rights. As I already told that in coming days, the long traditional way of measuring the wealth and property will not be the same. Earlier, we used to measure the one's well-being by purchasing whether he has bought some car or some wealth like that. Nowadays, in coming years, we are going to measure the property in terms of intellectual property. And that's why we need to train teachers as well as our students because so many of our students are creating digital content on social media, YouTube, or videos, blogs, and how to protect and how to get literature, how to create wealth by creating such as asset. That is one of the important points that we need to train our students. And that's why I congratulate Jadhav sir for taking the right step. And this is the right time to train our teachers so that they can train the students on create the awareness on intellectual property and how to protect them and how to create wealth out of that. So I hope that this faculty development program will achieve that goal. And I once again congratulate and welcome all the faculty members who are attending this FDP, and I welcome them all in the campus of Dr. Bhaskar.
Thank you so much, sir, for your words. Now it's time to hear our session chair, Honorable Vice Chancellor, Colonel Professor Dr. K.V. Kale, sir, whose leadership and vision have played a crucial role in shaping academic excellence at our university. We are honored to have with us now in place Honorable Vice Chancellor, Colonel Professor Dr. K.V. Kale, sir, to deliver keynote speech.
Good morning to all and all.
Good morning, sir.
Rather good afternoon. As because of the session is already started and by default we now get a morning session and just part of formality this inaugural session has been. Let me congratulate to all of you from various corners of Maharashtra and the country to get participated in these programs and let us accept contribution from our side. So all of the participants, those are physically and those are absentee applicable for this particular program. Let us thank to the Atal EICT, those who have selected this university for conducting this faculty development program. And under the coordination of Professor Bhato and Professor Gure. My fellow colleague, Professor Nambamawar, Professor Gure, in front of me, so many faculty members attending this program. And distinguished expert who are invited for the case of this particular occasion. Actually, IPR is one of the important concerns of my individual because of the maintaining the academic standards and research culture in the research and activity. But Professor Zado just give me the 5 to 10 minutes because of lot of concern that we give and we also. So I try to finish some basic objectives and objectives about the IPR. Some of the faculty project is good thing in front of my directors are in audience here. And hopefully for them, this is very important concept to adhere the IPR policy is on board in the academic and research activity there too. In meeting FDP, that is Faculty Development Program, why the government and the agencies are put there this faculty development program? Because our objective basic role is teaching and learning and research. And that was the development in sense of if you are going to implement the NDP 2020, earlier the condition and concerns are different. Researchers are used to research, produce a degree, publish the papers, and then having the patent, but what next? And the big question in front of all, what next? And some of the solutions has been assured during the NDP 2020, and the research and publications of the magazine exposure is on. not only just to publish and maintain their innovation, index and citation, but to technology transfer. When you are going to transfer the technology in terms of all, again, one important thing is behind this, those who have academic and verification level. For filing the patent and patent, you need not require the age, you need not require the gender, you need not require the qualification. Any persons on the surface of the earth, those who are having an innovation idea in their mind, here she can file the patent and transfer the technology. This is really important class. Again, from your student from second class to the master level, also file the patent. A farmer can file the patent. So please remove the mind concept that we are only the academic certification eligible for filing the patent. Now, the question why FDR, that is faculty development. Faculties are the backbone of the academicians institution as well as for the society who are throwing the light to the societal problem solution, to the government problem solution, to the innovation and idea. So what we require basically the transfer of the technology consists of the required solution or robust solution with the software name what it is like. If what it is like robust product, then it will be if it is a low cost, high throughput. And that's why there is a strong coupling and whether what terminology I can use in the software engineering, cohesion and coupling. There should be a strong coupling between the academician and technology transfer and lose cohesion in between two parameters. So cohesion and coupling terminology is used in the different way in different parameter. Now, my important point that I would like to focus in today's discussion, that is the intellectual property right. The word itself gives a very significant dictionary as well as written meaning. Intellectual, then property, and then right. And combined together with the IPR. This is very important technology set by the government of India and practitioners in the industry overall. So let us come to the intellectual. We are human being and basically intellectual animals. I say animal. There are other animals also those having some intellectual. So just on my parrot or just on my sparrow speak their shelter with a very quick way that we cannot able to follow. Right? So intellectual is always there, and we as an intellectual person require the different type of intellectual and want to suppose to transfer this intellectuality for the benefit of those who are large to technology transfer. That is one of the part. When you see the intellectual and when you see the property, so intellectual is what? It is the innovation, it is the research, and the innovations and research are supposed to be considered as well or themselves or institute of organization, which is supposed to be available in the market, which are available in the common platform. This is not supposed to be a common or earlier available people. So if you have to design, if you have to publish, if you write a book, if you write a story, narrate something, if you produce something with the help of intellectual property, that is the human resources mechanism. So intellectually is basically a base of knowledge based composition of a person, of organization, of institution, of a common purpose. And what is that property? Again, the meaning of the property is multiple ways. Tangible property and non-tangible property. The thing which can able to have, which is having the geotype, that is the property that we can purchase by and see with the help of data. But the property which are not able to see by data, say my algorithm, say my composition, say my formulation, or some other thing. But both the properties are created by the human being, and that's why the property having the importance of meaning. Hopefully, I think the organizers have said this before the some possibility of nature. What property means? What is the definition of the property itself? If it is a property, having some intellectual conceptual concerns specified by the newspaper or organization, then we can move further right. If this is my house, this is my land, this is my building, this is my property. And then we say the property then having the different concept. But I will concentrate on different aspect of the property. This is not supposed to be actually physically not tangible property. That is algorithm, that is some of the design, some of the process, some of the story, some of the code, some of the narration, some of the knowledge, also part of property. So intellectually, a person or group of persons or institutions created something new, which is innovative, which is not available in the world or universe for mechanism conversion. That is the intellectual property. There are so many things to say about the intellectuality. Maybe some of the experts is going to highlight what is the problem and what constitutes the intellectual. tangible, non-tangible, and constant, and it is not supposed to be approved and operational by any other agency around the world. Again, important point is that we as the university people, or institution people, work for the society and the meaning of the society, the whole universe. That means whatever the diversification research that we have, it is not limited for you and your city and your country. It is completely globally for benefit of all people. So it's a universal truth that you have to suppose to develop the intellectual property for the whole world. Now, when we say the whole world, then concept come into the force. And that's why the property, intellectual property, and rights. Who is going to possess the right of this particular property? Either you, your government, your country, or in a universe. Maybe I think there will be one session how to preserve the right, what is the right composition, what is the law conflict, and how we can find, and all these are the material things that we can learn from these 3, 4, 5 days. But the preservation of the right is required. If the property is gained by a particular person or particular entity or unity, and to preserve their own right, and if the product is going to manufacture and scale up for the industry, there is some royalties and all these other technical percentages of the picture. But intellectual property and right. So intellectuality is required. Then property, when we say the property, is that particular or the particular action in the particular outcome in the particular system turns the force that may very implement technological transfer. Then what is the property? If I design an algorithm, if I design a software, if I design a tool, if I design a machine, if I design a process of mechanism, and then we are going to convert it to the technological form, then it will be the property. When we say the property, then the property right supposed to be preserved, either individually or the group of institution. And how to preserve this right, there are some laws of consent. In Government of India, there has been a law for the IPR, that is a very old law. And that's why technology is coming to the picture, how to preserve the right, how to create the right composition, how to achieve the conflict level, and how to minimize the risk to get the disturbance of the right. So right is again the composition. My point here is that when you are having the property achieved and inherited and designed and able to transfer, then you is the property, your own property. Either you can sell, or you can able to transfer by your own way, or you can transfer it for scale up of other money. And then you have to set some term and condition for the property, and then it's right. So intellectually is the biggest issue, and nowadays ChatGPT, here you can generally create than our own innovation. But there has been a law internationally passed by and government of US and usually the government of India. No property intellectual has supposed to be considered as a patentable property if it is created by the artificial intelligence. That means the property or the intellectual required by your own way. Can use the machine, can take help of the tool, but that machine and tool should create that particular intellectual that is your own intellectual, then it comes to the idea. Otherwise, it is just for the narration, consumption, information, and telling the story for others. So that property doesn't consider. So I think latest combinations of the IPR are very important to learn. What is the intellectuality? How it comes to be intellectual? Which particular components are supposed to consider as intellectual? And what are the terms conditions to declare as an intellectual property? Before that, you require some particular combination for research. It's innovation. So research innovation publishing the paper requires some literature survey and literature review. So when you are going to start, suppose that I want to suppose to file a particular patent. What is the process for that? First of all, you should suppose to have the intellectual. To map the intellectual composition, my research supposed to be considered as a unique research. It has an innovation, it has a new thing, it is not supposed to be available elsewhere. If it is available, how it's supposed to be different than the available product or than the available idea than me that you have to justify with rigorous review. And you can see that even though idea website, there are various journals that are available worldwide. So when you find your idea, when you are going to consider want to convert this idea as new and innovative for the benefit of the society, another important point for filing the patent and completion of the property is that that idea, that work, that innovation should be a popular as well as transport service to give you the benefit at large of the company. So if I design particular thing which is applicable for one person, that's suppose not supposed to be done like that. So your IPR or patenting or idea, with that idea you generate something. So that idea and that conviction is supposed to be publicly at large. Now the question arises, if you are having a property, if you are the innovation, if you are publishing paper, so might be some sessions are proposed to be reserved for that, how to publish paper, how to make the indexing, how to make the consideration for filing paper. So filing the paper and generating the IPR, filing the patent requires a lot of clearances. The first requisite that is the research innovation and works with very innovative and new. It is not supposed to be copy and similar from others. And conduct requires review, work activity requires review, technological consent to consider. And when we say the paper is published, there is a consent, hence to publish and not to publish if you are supposed to have a patent. If you have the idea, you feel that this idea is supposed to be unique, you just take a overall the work and confirm yourself that this particular work is unique work, and then you can file the patent. Once you file the patent and it is published, then you are comfortable with law. No one is supposed to be there in the universe to achieve, to copy, to use that material without your consent. So the first and final story is that you may publish and then you can file. So I think Dr. Zadav has obtained some participation. This is very, very important for the young researchers. When to file, how to file, what is the innovation, what happens when published, what happened after published, what happened before published. That means what is the consent and criteria to file the patent is very, very important. Once you file, there are three compositions for the fifth party of the file. As I said, if you are very innovative, if you file, there are certain process mechanism, and that mechanism you own also you will not require to have to borrow or bother about the consultant. If you are studying proper way, you can file your own patent very easily with the minimum fees which are available on the website of the IPR. So then file the register and then publish. Publish is just like paper publish. Your ideas get published universally, and people are going to access. There has been time submitted for 6 months, 8 months, 2 years, 1 year maximum, and then work is getting observed by the people and compared by the people. If they say that the idea is very unique, not repetitive, not complicated, and it's very useful for the society at large, then they are going to publish it. And the publication numbers and title also get flashed on the website. Both the publication you hold, that is patent publication, first is paper filing and second paper publication. If it is published and if there are some minor tweaks or criteria, if the organizations are supposed to be authority are supposed to decide, there is examination. There are 3-4 levels of examination for patenting. And if you are going to cross this examination online, offline, then the final step goes to the patent granted. So filing, publishing, and granted. These are the three important steps for IPR. If the publication is granted, either you or institution or individual or a group, then the publication is ready for technological transfer. The first and last important step is the transfer of the technology. You have developed the idea, you have filed the patent, you have published this patent, and this patent is getting published, and then this patent is granted by the government of India. Then your work is ready to technology transfer. And it is again user of the patenter or application the concern that you are going to publish this particular patent and transfer the technology. You require the incubation center, you require the startup mechanism, and you require the industry support. You want to design a mobile very excellent that is different features and different competition. Now, because of the material capabilities and financial capital, you are not able to support to do it. So you have to adopt some company, and government also will be able to support you as a startup. And if that particular startup is a prototype product, if the prototype is well established and phase one, then automatically government and different player of the industry come to picture to scale that particular product. So this is the short pathway which I would like to put in front of you. Innovation, publication, your idea, its usefulness, then file the patent, publish the patent, and grant the patent. And after granting, then your work, your idea, your algorithm, your system, your process is ready for use by the your own way, by the consultancy services, by the startup, or by the company which are supposed to take it for scaling up. So these 4 5 fundamentals here is very important, and I think these organizations, the people those from here are coming from, even private or government doesn't matter. You can consider yourself as a patented your grant and the grant patented product or idea or process or mechanism ready for the product. Now this is the short pathway, and you as the participant, yes, ask the bombarding question to the panelist or to the expert and get clear more and more. Why? Because there is a lot of confusion. I word is specifically very authentically confusion all over the world about technology transfer and patenting. When I publish a paper, when I patented it in India, I cannot produce that particular product beyond India. So, point is, the patenting right and authority of the Indian government is different, Australian government is different, USA government is different, Europe government is different, because that product is scaled up in their own country. And if you want to suppose the universal product positioning just like a mobile, which is supposed to market the whole world, then you have to again apply, reapply for the granting of the patent worldwide. If you want to manufacture that product in America, you have to apply for that patent in USA. You want to product this in China and Korea, you have to apply. Here is that the IPR for India is different, IPR for US is different, IPR for Australia is different, and they have the different fees and charges because your idea, your product, your innovation is suitable for their country to make that particular product available in their own use. So, dear friend, patenting the paper, that is publishing the paper in one consent. If paper is very not true, you have to file the patent, and before filing the patent, you have to file your idea in very systematic and approachable, so that tomorrow cannot be able to copy and you can enjoy your life. Once you transfer your technology, either in your own way or industry, then you have for IPR. Your property gets preserved. You have your own consent and empowerment. Without your consent, no one is there in the whole universe. Copy, to track it, or use it without your permission and your consent. That is what the IPR is about. And as per the NEP, either it was just used for the master level and the student and those who are doing the putting the research for them only. But hence onward, the government of India in whole universe, these complete parallel are removed interdisciplinary, transdisciplinary, multidisciplinary, interinstitutional, within the institutional, within different plans, you can compose clearly the idea and filing the patent for the benefit of all. And that's why under the NP 2020, apart from the teaching and learning, research and innovations and patent and research is important. And hence onward, on more application work that I am going to put in front of you, individual identity and institutional identity, apart from teaching, learning, how long you are, how subject you teach, how many years that you teach, then how many technology transfer that you have made. And in the technology transfer patent is developed and it is scale up, what is the use of that particular patent, what is the use of that particular technology, and what is the use of that particular product. If it is a large benefit for all, then that will be the very high value. So point is, hence onward, NAC and NBA is going to change or in their criteria. Maybe after 3-4 months, we will get that particular paper. There you can have only identity of the individual, that's me and you, is basically based on your IPR patent and able to transfer, and similarly for institution also. So I think various experts are providing their thought, maybe very fruitful and useful to you to process this mechanism in a very rigorous way. Law of viability, technical complexity, then how much charge is also a big question. If I publish a patent and grant the patent and you are supposed to become a person, I don't know how much cost is supposed to be. So costing effective mechanism, then you are going to product become a more rich, then the conflict are just later on. So conflict is risk minimization, taking the handwork, taking the stakeholder, setting the cost, preserving the ideas, and again you have to republish it, remodify it. These are all the technology terms, and that's why some institution MTech program or master program in IPR also able to start. This is very new branch, techno-legal branch, technology branch, techno-design branch, which are supposed to be required for IPR for good. So don't be considered that you are just engineer, you are just a PhD, or just economics, you are just university, all are required in the patent competition. So my dear friend, I once again welcome to all, and hopefully you just understand why you are going to attend this particular program. Ask the question to yourself. And what are the limitations? Tomorrow, after completing of this particular workshop, if you go to your hometown and home institution, ask the question to yourself. Now I want to start to file the patent. From where suppose I start. So you require the rigorous study, require innovation, require idea, very honest and transparent compositions of your research. The research supposed to be quite for the benefit of the society. Once it is, then you are ready. Law 2016, I give my example, you know very well. We have filed directly 10 patent. Out of 10, now 25 who are granted in India, who are in international and carry pipeline. So there is history in Aurangabad city, particularly industry person filed 20 patent directly, and out of 20 is an electronic person. He is having electronic industry in Aurangabad, granted up to 10 rounds and share in the pipeline. So granting the patent is a prestigious, but that is not enough under 2020 an academician. You have to suppose to make it transfer. If it is then transfer, make it easy for society. I have 300 people, 400 people, 40 research students, so it will that is useless. How much of it is for the society, that's important. That's why I can become more important, and that's why the academic center is focusing more and more on the IPR to empower and create the knowledge about the society and gain more research and feature. We have the farming stations, quick instructions, and try to motivate the people to make a self-sustained to the more idea. तो आत्मनिर्भर भारत विकसित भारत जो हम खाद देख रहे हैं तो ये संशोधन नहीं होता है when you are doing this well then definitely you make the Indian very proud and give the directives and direction to the nation under software industries and AI. You can see the real big share in the market all basically here from India. And Indian having their particular values, Indian having their particular knowledge, their passionation, patience, dedication, determination, and definitely India will evolve tomorrow in terms of technology. And technology for betterment of the society, technology for society, technology for man. If you are doing this, then definitely will become a आत्मनिर्भर भारत विकसित भारत एंड जो पूर्वजन हमारे कल्चरल मामला यूनिवर्सिटी थे वैसे भी हमारे इंस्टीट्यूशन बन जाएंगे और दुनिया भर के लोग हमारे पास आके हमारे ज्ञान संपादन करेंगे एंड दैट्स व्हाई आईपीएस इज अ टर्मिनोलॉजी हैज बीन रिमूव्ड भारतीय ज्ञान परंपरा हमारे बहुत ज्ञान परंपरा सिविल में है टेक्निकल में है इंजीनियरिंग में है एग्रीकल्चर में है इकोनॉमिक्स में है मैथमेटिक्स में है when we are going to encounter this convert to technology to some work identify the need of the society and try to develop your own way to help them to the solution and to take out then it will be fruitful for the idea then the real academic transformation of the technology for the people of the society. So hopefully I will meet you again later on. Just a review and some question answer session in between 3-4 days. But let us ask yourself the first question: why you are here? What is your objective? What you are going to learn? And what was the content covered by this particular workshop? If it is not, you can ask them. I will get away from the library or the resources and try to learn more and more so that you can be able to get ready as workshop product later on after finishing the workshop or filing the patent. So with this keyword, let me thank and welcome all of you again to the Day1 campus. The campus is very beautiful. You can learn from the society also. You can learn from the nature also. Apart from things you can also, and you can see and express each other how to resolve the conflict of the in past. Thank you very much.
I extend my sincere gratitude to our Honorable Vice Chancellor for the opportunity, sir, for enlightening in your speech. Sir, your inspiring words have provided valuable insight and set the perfect tone for the journey. Thank you, sir, for your time and wisdom. As we are at the end of our session, it's time to express our gratitude to all those who have made this event possible. It's my privilege to honor to propose a vote of thanks on this special occasion of the National Community Development Program on intellectual property rights. First and foremost, I extend my heartfelt gratitude to other academy for providing us with this valuable platform for organizing this activity and for their continued support for fostering academic excellence. A special thanks to our esteemed session chair, Honorable Vice Chancellor, Dr. Professor K. Kali sir, for inspiring me your address and gracing this event with this present. Sir, your focus has laid a strong foundation for the session today. I sincerely thank respected President Dr. A. W. K. sir for his encouragement and support in making this event possible. I'm also grateful. I'm also grateful to respected Dean Dr. Sir, for their valuable guidance and continuous support in shaping this program. Sincere gratitude to all the head of department for their cooperation and active participation in making this event successful. I extend my heartfelt gratitude to all the experts who have graciously accepted our invitation to attend the session, and special thanks to Dr. Manish Kumar Polekar, Dr. Govind, Dr. Amit Devdekar sir for their esteemed presence at the inaugural function. A special note of thanks to my dear colleagues, faculty members, and the volunteers for their dedication and efforts in organizing this activity. Your support has been instrumental in ensuring its smooth execution. Finally, I extend my deepest gratitude to all the participants for their enthusiastic response and for being a part of this academic journey. Your presence and engagement will make this activity truly enriching. With this, I conclude my words of gratitude and once again thank each and every one of you for your valuable time and support. Thank you. Now, I will take how to ask people to come forward for the decision. It is kind of clear, this is already function home.
One before we are taking the beginning. The slides comes from because I requested to arrange the participants. Okay, so we have to my school. IT Patna. Yes, double. Technology वगैरह करा था एक बार प्लान किया गौरी मैडम फ्रॉम आईटी सर नहीं हम सब इसे कुछ बात महाराष्ट्र
मी छोटे फ्रेंड जाऊंगी
हो
माझी जावई पण डायरेक्ट इंग्लिश कॉलेज छान
वेलकम तू वर्कशॉप कसं काय समजायचं करून टाकतो आता पुढे काय आणखी तुला सुद्धा मला दोन मिनिट खूप छान कसं घेणार कुठं एक दोन चार असं चेअर असे करतात काही मला वाटतं हे बसायच्या रिसोर्स पर्सन सगळे किंवा काही असेल वर पण एवढं लांब येणार जेवण चालते वर एक वाशी करणार कुठे येईल का कोण काढतो खाली बसून घ्यायचं का आणि एक भाऊ असे विषय तर काही नसते आमच्यामध्ये हा स्क्रीन सोडून तीन चार स्क्रीन फक्त दिसला पाहिजे आणि काही खाली वाटत सोडून काही या साईडला काही या कसं आहे पुढे या फोटो या पटकन सृष्टी या बेटा सिंगर साहेब या विद्यापीठात या इथे कसा वा साईड जातात फक्त फोटो भेटून लाव म्हणजे बरं सीईटी सीईटी या बसा बसा पटपट बसा उशीर व्हायला सांगा जायचं वेळ आहे सुट्टी बसायचं पटपट या आता स्क्रीन कवर होईल बघा तुम्हाला लागेल हा स्क्रीनचं थोडंसं इकडे हा स्क्रीन लागणार आहे आपल्याला थोडंसं या सर हा ओपन होत असेल थोडंसं या आपण त्या साईड असेल थोडंसं इकडे असेल सरांचा फोटो येत नाही का थोडंसं थोडंसं असं थोडंसं 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 बॅनर येते ना होईल
Thank you. Thank you and all the best. तुमच्या आयडिया तुम्हाला काहीतरी आणि आपला वन नेशन वन डेटा सीझन आहे त्या लाईव्हला बघून घ्या त्याला टाइम राहिलं ऍक्सेस द्या तिथे आपला तो एक महत्वाचा मुद्दा आहे वन नेशन वन सर्व्हिशन आपलं कल्पना असेल सगळ्या भारतातून जोडलं तिथे You not being required to go for IPR or transition. आपल्या लाईव्हला एक्स्ट्रा ठीक आहे तुला सही साधेल तर जेव्हा आम्ही दुसऱ्या कामात आहे बिझी यांना काय करायचं टेम्पररी सांगून पालकांना टेम्पररी ओपन करा यांनी मला लायब्ररी
Participants, please be seated. Participants, please be seated.
Now, it's time to hear from our senior expert, Dr. Mohit Kumar Kolekar, sir. He will guide, who is the expert on AI. He will guide on.
Sir, Dr. chair खाली हटा. Sir, let's. Participants, now actually in the schedule we are having the article, research article, and that article will conduct today after the session only. However, we are very fortunate. We are having with us Mahesh Kumar Kolekar. He is working on various scientific projects in government of India and important projects. Also, he is working on projects of government of India, particularly in AI, artificial intelligence, and nowadays we know that our work, how our work is simplified by ChatGPT and AI. Even today, we are relying to draft our emails or whatever our slides, whatever presentations, we rely on artificial intelligence only. And then we are just configuring it or just editing that the slides or whatever work is there, whatever help is required, whatever query is there in our mindset, we are solving or trying to solve that type of it as AI. Even coding, nowadays coder has gone. How did we can say? Any suppose I need any Excel formula, so no need to remember any Excel formula. Just to ask the AI. I need some sorting, or I need the count of so and so row, or I need average, or I need to declare the result of so and so column. Likewise, so many things we can do in minutes. And in this area, Dr. Mahesh Kolekar is already working, and he has shown interest to address the gathering over here on the AI. So I request Dr. Mahesh Kumar Kolekar, Professor from IT Patna, to take the charge and deliver the session. Sir, I request you, please try to wind up within half an hour because we are having a lunch later on and other schedules. So half an hour is with you, sir. I request Dr. Kolekar to take the charge. Thank you. I will try to because of how it is. During my session, I will talk about the IPR, which is position of another thing. And since because the other talk on the AI, we are against the development or change in our unit life because of AI. No period of time. Everywhere the AI is there. AI is everywhere. You know, easy to say, innovation, AI is secondly more. So we can now history. The first artificial neural network was in 1957, or we got independence in 1957. Just 10 years after that, this perceptron was proposed, and the modern deep neural network is based on that. So you can imagine the history long back. Okay? And then there are many projects are there because of time I will not name all those. But key projects you can say today, one of them is Jeffrey Hinton. Do you have this name? Jeffrey Hinton. So he proposed a back proportion algorithm in 1988. 1988 he proposed. And without this back proportion algorithm, not deep neural network trained. You cannot train deep neural network. So such a revolutionary invention it was. But this Nobel Laureate committee took so much time. They awarded him a Nobel Prize in 2024, just last year. So you can imagine the span 1988 to 2024. So why he was not awarded before that? The reason is have many things, competition power and other things, but this reduction was not in the light, okay, because nobody was looking in this area. Even after 1988, just after 2 years, many researchers thought that this AI is not much useful. There is no need to invest the money, no need to go for the research, okay. So obviously we left it, but still many contributors, many self-inspired researchers contributed, and that's why you have the popular next machine, during that period, okay. And so this 1990 onwards, even you can extend up to the line, that period of what is AI winter period. Means in north side there's a lot of winter, east side a lot of grace. Okay, it's a sleepy type of there. So that's why the term AI winter was used. And no research on the AI. Because again this AI was a lot of computational power as mentioned. So in spite of those also AI didn't progress. Lot of funny people was having lot of hardware, lot of parallel devices. You have to invented supercomputer in India. So in spite of that, this AI was not progress. So AI progress 2009. So why I'm saying this 2009 is a landmark year? GPU, this is hardware actually. Everything is hardware. So it's a money matter. If you have money, you purchase very high hardware. But it was the algorithm, it was the database. These all deep learning algorithms requires large data. Large data. And the more the data, better the result, better the accuracy. That was the so in 2009, one group from Princeton University, USA, they published one paper in the CVPR conference. CVPR is a star conference. Even it's better than many IPR transactions journals. And full form of CVPR is revision and pattern recognition. After 2 years of published one paper in last year, okay, with the same purpose. Our first paper came related from IIT is CVPR conference. So, I brought my students in my certificate. So in that conference, they published one paper called immediate database, immediate database. This crystal group. And they released this database after publication of that paper. And that's why we are increasing the AI. That's why we are opening the AI branches in our university. Okay. So what they did actually, they opened this database free for everybody. They didn't go for the patent or didn't go for the business. Okay. Everything is not a business, everything is not for money. Because they are making a lot of credit because of that. Their paper is highly cited, paper. And second thing, they got the patent for other ways. Okay. They earn the money, but not directly. They open the society to work on this database. And that's why they conducted one competition from 2010 to 2017. 2010, 2011, 2012, 2013, every year. And every year they used to select one winner for that competition. Name of the competition is ISPRC. Do you know the full form of ISPRC? Imagine large scale visual recognition challenge. ISPRC. And 2010, there was one winner, then 2011, 2012. Again, this guy, Jeffrey Hinton, he proposed one model called as Alexa. Alexa is the first model who has used CNN, convolutional neural network. Have you heard of convolutional neural network? It's very common. It's also a milestone. So this is another milestone for the development of the AI. And convolution was there actually, historically, even 80s of convolution was there. But he used that convolution formula. Convolution formula is very big mathematics. Just the relation between two signals, f of x and g of x, two signals. So they will find the relation. So there is a Fourier transform theorem of this, right? That convolution in the time domain is equal to multiplication in which basic domain or vice versa. So he proposed that convolution neural network, and then there is no need to extract the features independently. Features can extract automatically using this convolution because so this happened without till then he didn't get the Nobel Prize. So he was limited situations, means he was not working for the Nobel Prize, but he still didn't get the Nobel Prize. And then in 2015, this competition was with a single objective. There was only one target. That we are giving the data freely for unit P, unit P will come up with one algorithm or one model, and we will just measure the error. Okay. And whosoever model has the less error, we will do the winner. So this was the criteria. Only reduction of the error was the criteria. No restriction. So in 2015, Nestle 152 got the award. Okay. And these are proposed by many IT industries. I will not name them, including Google, Google Data Solution. So Nestle 152, and their accuracy level is 3.5%. Okay, 3.5%. And human accuracy or human error is 5%. So 2015 onwards, similar models proposed or winner of the competition, 2015, 17, are able to accuracy less than 5%, that is 3.5, 3.4, something like that. So then these are stopped or they will be connecting, but not purchased to this competition. Because we have crossed the limit, our error rate is better than human error. If I ask human to classify these objects, if I give thousands of images of cat and dog, and I ask somebody to do the labels, so there's a 5% chance that because of cutting and other reasons, he may say cat is dog. Okay. So his error rate is at 5%. So that's why people started telling that machines are working better than human. This is not fair. Machines are working better than human. That's why Shivaji mentioned our video before. Okay. So robot is not part of working hard, plus for accuracy. So then 2015 is so after that then there is no need of the model. So many models are here. But here what cost to take is the number of layers. 152 replaces the number of layers. Initial models were less numbers. So more the layers, better the accuracy. What you have to see. After this also, people started working on deep learning. Then next thing what happened? This is okay for imaginary data. If I want to work on the medical problem and brain tumor detection problem, then what I will do? I need some separate data, new data set. So that's why I will get the brain tumor images from the hospitals. And if I have a connection to hospital, I will get 3D or 5D from the hospital. So I can get 1,000 images of the MRI. But I want to classify it. Healthy person and cancer person. So I want a MRI 1,000 healthy person. So you can imagine the cost of getting the MRI 1,000 healthy person. 1,000 MRI charge right now. So money 50 lakhs or more than that. No. So that is not the issue again. Money is not issue. Forget about the money. We can teach for the the question is about the willingness. Whether participants ready to go for the MRI, healthy participant. Certainly not. Because there are some side effects also. Unnecessary nobody should go for the MRI. MRI analysis. And this is really required. That's why doctors also advise after 3 months or 4 or 6 months to get the cancer patient also. Even for the MRI. This is one thing. So in such case, it's very difficult to generate the data. That's why the generative AI came. Generative AI, as the name indicates, it generates images. That's why generative AI. So it generates some fake images. Now, how to generate the images? Which tool we should use? So that was a problem. Then again, it's a risk time. Thinking about this. Then they thought that okay, we have seen the development because of the AI only, because of the big networks. Why not use same models for generating big images? So for deep learning training purpose, we are using another deep neural network to generate the images, fake images, looking like the original images. And that's what the generative AI did. This is the development last decade, not more than 5 to 6 years. Okay. And here also there are three types of generative AI. Do you know the three types? It is one type of generative AI. What? Distributed is generated, but it is called as generative adversarial network. So this is one type. Another is the autoencoder, and third type is a transformer. And special case of the transformer is your chat GPT. Okay, what you are using chat GPT is the example of the transformer. So these three types of the generator. Then again, these are the producing the paper. They combine two papers and say, yeah, they use autoencoder also. They will use GAN also, or they will use transformer also. Because people have only people have resources, they are very ready to wait for the results. Okay. But they want to improve result. Everybody want now quality result. Okay. So this is the so this is about the generative AI. Everything is okay actually, unless and until we are using technology for good cause. But there are side effects also. Once we started generating fake images, looking at the original images, people started to misuse this technology. For example, in election, a lot of people use this technology. Election, we have faced many elections recently. So there we can generate like Modi ji used to talk in front of the powers and technology. That we can generate artificially, fake news. But what we were taking you are the audience. Same point, same audience. So people look at topic को लेकर they want to without saying what we are taking. We all are here, but only the speaker is different. And he's going to everybody. So all those things can be generated using the very easily, very cheap. That is the beauty of this AI. This is also okay, but people are started using this for deep fake issue. Deep fake means same celebrity, Carlo or this celebrity. We can generate some dirty images by using this AI techniques, realistic images, not fake images. Fake images look like the real images. So these are some advantages, and this type of things force to change our ITF. You know ITF? There is an ITF in ITF means Information Technology Act. So now there's a pressure government of India also that we have to check so many cases are report cyber security cases. I'm working in the forensic area, so I know many things. So now there's a pressure to change or modify the act also. And you are there also we need to follow the IPR also. This is why it 5% they should not use without the permission. There also IPR also can introduce this somehow. So all these things are okay. Now we are next question will be what's after AI. After AI. This will be the obvious question, right? We have seen a lot of development here. So next question, next is after AI, there will be AGI. Have you heard this word AGI? AGI means
General artificial intelligence.
General artificial intelligence. The AGI means artificial general intelligence. General means human has a common sense, which machine don't have common sense. So we want to develop machines so they will think like a human. They will give you some cognitive capability of the human. Like we say we proudly that we invented AI. AI is human's innovation. So similarly in future there will be the innovation by machine itself. Both you don't know. So machine will take decision. Like for a wireless machine will use whatever they available information, machine will develop the corona vaccine. So people are so these things are vague. At this point of time, we will think that these things are vague. But the same thing people thought about AI also, and AI can reality. So AJ also make it into reality. We don't know. So it's a limited issue from just I have given this as a open problem to you, so you can contribute in this area. So we want the AI machines which have their own creativity at least creativity. So thinking, creativity, all those things. So that's about the AGI. And many things our country is also doing a lot of focus. India AI is also vision. So you have to be AI literate, like that. There was like MSc, long time MSc was there, so computer awareness. So similarly, in future there will be AI awareness. Secondly, even AI likely has started. My mind put like some data out of the AI. So how people are working on AI, what is their contribution, difference and applications on AI. And even my background is I'm working in department, I did PhD in electronics department, I did postdoc from computer science department in USA. And still I'm focusing on AI because it's a need of the hour. So, yeah, so we don't we can debate actually AI has used the job markets, accept the situation and start looking into, yeah, this is the message. Uh, so that's all I think, because everybody is struggling and I was struggling, so it's all here. Do you have questions? I can answer the questions. So this is me, I thought it makes a different things. I studied this. So it's very interesting to study history. History of the historical place. I can historical place. So you know the history of the soil mass, and then you should know the history of the AI also. And you know who is the godfather of the AI? Can you name him, sir? Can you guess? Jeffrey Hinton, who got the award? Now people started saying him godfather. Before that, nobody was asking him. Okay. Nobody was getting recognized. So I think like the innovation of question that you are awarded for the early innovation. That's the question. But actually for that truly importance came, there is the importance and everything happened because of the 2009 paper. He got the award because of this external university division data set. They published, that's why there was a development in the you see this miracle they didn't charge it and they didn't pay it. Okay? They came with the output, they thought no we use my data and I will have a fair competition. Very important. So we tell the IPS but everything is not for business actually. That's why many things we are not patented, like price and other things. We are not because of test credits, your paracetamol medicine. I heard some cases sweet. And all these two things not patented, that's why they have easily available. 5 rupees, 5 paracetamol, the cost of the dosing of paracetamol. And we even exported this paracetamol to the USA to get product. So that was our invention and we have patent. It's all patented in such a way that cost will be minimized. Otherwise, we have to pay for fees for the paracetamol. It was possible. So depending on the countries, go for the pedals, telling the other parts of the patent also. And that's why butterfly is okay actually. Work with patents. You go for the patents which are really meaningful. And like for patent, another thing, yeah, so AI is developing. For AI people, it's a different patent. As I mentioned, that software and algorithms cannot be patented. It's not the full story, it's the half story. You use a software in case of hardware, and then it's the intelligence product and patent. That's a mini gadgets like washing machine, we have AI washing machine. You see, they will see more of AI. So because it's a program, there's a program actually, that 15 minutes, this one. Everything is managed. You increase the load unnecessary, program is compared to capacity to manage the speed. So then the machine will not be damaged. Previously, there was no program machine to run at a constant speed, and this will the load. So AI is a boon actually, but unfortunately, so we should give AI.
We sincerely thank Dr. Goenka sir for his insightful session on AI training. This expertise has given us a deeper understanding of AI evolution and impact.
One picture that natural touching is very honest. According to participants from outside, इसकी देखो गवर्नर हमारा का मतलब राज्यसभा का अपना आपका समूह है people from outside Maharashtra for example so Andhra Pradesh from Andhra Pradesh state they are last Diva Kishan is there Ajay Kumar Pandey from Uttar Pradesh. Is there any other person from outside Maharashtra, madam? I think two participants from outside Maharashtra. So now we are running late now break for lunch. Immediately we have a section. Madam, what is the time for second section? Huh? 2 to 4. Like, don't know what they are. Now it's 2 to 2. So we have a break. And at what time you can gather participants? What time you can come back? Quarter to 3. Quarter to 3, I think sufficient. If just welcome of participants by asking welcome of the host and immediately to lunch. And then we are in the canteen and quarter to 3 is again assemble. Madam, quarter to 3 sufficient? Participants? Quarter to 3 sufficient? So, and as for the instruction from Honorable Vice Chancellor, he asked to between the librarian to create your library access ID. So whenever you get time in the evening, like, so you can visit our library, interlibrary, and select some article related topics. Because the 2 articles are there, I will be given to the as per the FDP schedule. 2 articles are to research papers we have to study and we will make the report of that by forming the groups. So if you require any journals or whatever resource other than the research papers, you can make in the library. And those who are interested to come for industry visit, I think 28th of this month, February, only, we are asking a visit to agriculture, agriculture, Dr. Punjab, Bala Sahib Sawan, Kokan Krishi Vidyapit, Dapoli, district Raigad. So they are having very nice setup over there, and we are having some work station also there, and very nice beach is there, Samudra Kinara. So we will be having our quality time over there. Maybe sunset we will have over there, and we come back by time. So please give your dates today only, so that planning your vehicle and all the necessary will be easier for us. Thank you, Madam. You can take over now.
Thank you, participant. You can proceed further at 2:45 p.m. Evening. She has presented her research work in various international conferences organized at various places across the world, such as USA, Canada, England, France, Dubai, and many more. She worked as a guest editor for special issues published by In the Science MIPS 2014. She has organized a few national and international conferences on IPR. MIPS 2014 International Conference Proceeding is published by Elsewhere, for which she is a co-editor. She has developed 5 courses which are available online free of cost and benefited almost 1 lakh plus learners. She has been a resource person in various programs such as FDPs, conference, seminars, and delivered keynotes, invited talks on various IP topics. As a patent associate, she handled a number of projects such as patent filing, IP auditing, patent mining, patent searching and drafting, oppositions, IP valuations, competitive intelligence, technology landscapes, technology transfer, FTOs, patentability search reports, and so on. She has developed various tools and models for IP management, and she helps organizations in their IP portfolio managements. She do provide consultancies to private organizations in various IP subdomains. We do organize IP workshops and IP clinics to help inventors for identification of invention for patent filing, along with further management and commercialization. She is an advisory committee of several institutions. She has conducted several consultancy and research projects for government and non-government organizations. Currently, she is working as an assistant professor at IIT Kharagpur. Now I request Gauri ma'am to start the session. Mic is open. The audible. Very small. Right.
कैमरा चल
You have already done the work. You have 5 pages. You have it right away. So, if you feel it is repetitive, stop. I will take the next step. Don't know how to stop it, ask me to do it. So, next 3 hours, we are doing this. I am saying, artists after doing this, and then I have recorded session. Probably 20 hours, that 3 hours, let me come. 15 that can convert to English. Commercialization in the next step. They don't have to. So I said, if you have any issue, stop it. Without any motive. So, and so this in the morning we have a session of listening for 90. So, some questions probably that one might order in your mind when you are thinking about IP. That yes, what is IPR? Then which are the different acts that it prohibits? Relevance with science and technology, because we mostly hear of science and technology. Then definitions and rights. Probably we will not go much into that. We will just see in angle as a individual. How to fight it, we are not interested in that. We should know what is required to file the patent. Then patent filing in India, sorry, taking registration matter. But I will just give you the statutory provisions in law of filing. And then PCT filing. So these are the two questions we more things are as we go into the details, we will just okay. Now, project planning, that is was one important because we are now dealing with students who might be doing some project or you want to own research. So always I feel that and I feel that at least we have to see in a zero time whenever we are submitting that project and how many patents are possible now. Different ideas are there, but as a science and technology person, I think that we should just think about how many IPs, different IPs, but as a science tech people, I will research. So, any answer to this on side? The exclusive, right? Okay.
I think you want to based on size.
Right. Okay. Okay. What do you understand by patent?
Patents are used before the industry position
Okay.
into the movement.
Like patent?
Based on the patent, patent, 20 years, copyright 60 years, 30%.
Okay. What do you understand by patent?
Domains, right? Domains.
We understand the time. Okay. Patent presents some of the right, infringement. Yeah. Then what do you understand by inventor? Okay. I'm just showing you. This is like fabric for the so which type of fabric? Yeah. Then
Copyright.
patent, copyright, trademark, trade secret.
You
Whether it will be applied in oh yeah. I'm just want to relate this fabric, different fabrics with the icing.
Okay.
Yeah, it's definitely. Yes, then copyright, how it is.
Types of design.
Design is a different. Design patent is industrial design. How is industrial design?
Because I'm not splitting gears at the size shape. No calculation.
So all design is for you. With this fabrics, you will get design, industrial design information. Okay, like copyright, how does it?
But printing is better works as that printing might be able to cooperate.
Okay.
Particular copyright by branding.
Copyright by branding.
Purchase and not
Yeah,
adding your
type of fabric and copyright. What is it?
actually it's a patent actually. Design means there means art. Art. Today in that and on that.
On that. Copyright. Then you have to make trademark. Yeah. Patent, copyright, trademark. Any for example, yeah, fabric.
In Hindustan, there is a viewership operator called 50. 50% trademark.
Please. Okay. Yeah. Also, okay, so all four types. The remaining four types. Did you get that? Geographical location. Yeah. Next. Any formula. Taste. Yes, it happened. I think other than that, we have procedure. Definitely means things if you do, then you have the production of from where? For the India policy Agreements is such a popular company. They have done the overproduction of them. Overproduction means they are supplying to world, ready to supply to world. That's okay. So my student was saying, madam, one day we would run one something like the big number, yes, like 1,000 1 million kind of meter of a family or more than that, they are making money. So that is the production we will reach of a family. Because we are supplying to the world, right? So urban mills, when we are talking about that urban mills, this urban mills, they started in Sagi. Then they have like intervened to that other many many. This daily production, you see the portfolio. Portfolio is not a
collection of things that we
collection. So, well portfolio you have, like you have mutual fund, you have some assets, property, I will invest some in analyzing, that you have portfolio. So this is your wealth portfolio, demat account and all. Okay. Now we are talking about IT portfolio. You know now 8 types of IT. So these 8 types of ITs, how many are with you? Okay, so that is your own. So single individual also can have his own IT. What do you think? One person, how many patents is possible?
is supplied from medicine. Example, like medicine, you can produce hundreds of products.
How many patents are filed by 1,074? 1,074 patents are filed by ADC, right? And he is such a good inventor that he has both the specialty. Generally, inventors are not independent or a businessman. Businessman also and design indicate. We know that is what the we like a subsidy example, 0.6% all companies. That is the C, right? This is one example. There are two inventors who are having more than 50 lakh per one single pill. Temporary is thus silver blue business. They have 5,000 plus. So we are just again one pill. I have already 5,000. See in IIT, some people are up to 150 plus. The common. There are at least in IIT, if you see at least 150 plus. That is a student. 150 commercial items. Not 50 patent. I am very clear on that. I say, if somebody say patent, if you may have only one patent, but how many are covered? Doesn't matter, 100 patents to 80 you are the serious. If you have approached that, by find one patent, and commercialize. Find one patent and commercialize. We don't to be wrong or anything. So that power is there. We have to just identify. Probably we may not be able to focus on because we are not confident about it. That is very complex. But if our patent is so powerful, then probably that I clearly say, I think you are taking it for the nothing we are not going to do another time. Otherwise, we will say the lighter. Again, solution here. Strategic. Right? We should think about that commercial language. So, when we are talking about this, why types you have told me, basically. I was talking about arguments. And arguments are classification. Telling you for your class, there are more than 8 pages of telling you even how to manufacture that and how to give that. Okay, so very classic example. Telling production. Right? Now, okay. Now, who are in plant varieties and farmers like and semi-production? Whether we can apply it here? Plant variety we can apply. Type of product. Choose. So, and then now banana is used and other things here using fibers. Protection of language. Probably we will have some different specific plants also in future. That's specifically again for a specific type of pattern we can do, right? Some other quality can. So that possibility. Semiconductor लगा सकते हैं किड्स लगा सकते हैं
If you are developing machinery suitable for the fabricate of that.
okay machinery में memory since even it is back end and they are doing a fabric production they are using machine obviously machines probably semiconductor now any other thing
If we invent a device which can scan and genuinely tell you the genuine question earlier and the limitation.
okay so all this
Based on the color, dye, texture.
it will be a very good solution. Somebody creates that very good idea will be created. So that's classic HP. Anything else? So all these are related to mind. Which you can apply on fabric. Anything else? Smart fabrics. Now if you prepare smart fabrics, especially if you think about the military and all that. Just imagine for military or some fabric which keeps you cool. So if for that some circuit is used, then probably we have this. Right? So this one map and it is related to different types of fabrics, all types of IPR. And in India we have a different type, right? Not in the world in jurisdiction that type. Okay. Now, any doubt anybody? Next. This is now Kansas image.
Most of the times, if you purchase a laser, there are a number of brands and location will be good to them. Tool is available in the market. Same thing.
So, patent is unique, novelty is very good. Trademark and child usually cross something. Like the same one.
Branding is great.
So branding is a different types of IP dedicated. Brand is a marketing term. Trademark is a legal term. Second means the state trademark. For branding, we will say it as a management. So you take any example. Laptops are there, trademark, mobiles are there. You get variety. The figures are there. According to trademarks are there. Trademark is giving who is the information about who is the doing. So now what you have to do as a patent agent now it makes sense and then if you suppose it come with this kind of thing, I would say that perfectly fine. Section 3K will say that algorithm is not patent. My duty is your invention to fit into the patent. So there are guidelines. So I will not cross the guidelines, but there are very wonderful guidelines are there for the examination of that specific inventions. So through that guidelines, what is the sir also told in the morning. Use that algorithm. Either you fit into the some hardware already existing. That is one option. And second thing is that you can create your own hardware, some gadget by using that. So for example, now you say that your washing machine is a automatic. Why it is automatic? Who is doing it automatic? Algorithms are making it. Shopping malls, because we create the kiosk. That machine. Suppose I'm buying a particular daily picture. I want to check whether it is available. So I can use that kiosk and that kiosk will check. So that will be wonderful. So you need not to actually you will if you create something like that, probably you will go for a certification trademark. You can have your own with this as a certification trademark. Certifying agency can be like apply your gadget apply for that. That's a wonderful idea. Right? Yeah. So now this is a different answers of things. Now you think about different types of categories. Okay, that's fine.
If I created a composition of lyrics, I can calculate it. If I created a particular composition of music, I calculate it. And and the choreography sequence can work. And traditional dances generally have a set type of musical instrument which are generally come. If someone invents a new musical instrument that goes well with that instrument per se can be better.
Patent is possible, copyright is possible. Next. How?
Different states have their own classical dance.
He's talking about dance. This is dance.
Practically,
But one thing, geographical indications for articles, some for services, some for the dance. Processes के लिए देखेंगे geographical indications only for articles. That should be the assessment. Processes are geographical indications protection is not
only for physically.
we should have something tangible. So it can be agricultural good, it can be manufactured good, it can be handicrafts, it can be like products, local products which you are getting a combination of local and the natural. Like combination of otherwise GI is not right. Now tell me how to get that. The second is the same thing, is the second. Caution. The cautions you can go into the geographically. Maybe we can. So caution will be there, but some tangible thing will come. Chandari sari, Pashmina shawl, all these are GI. The cautions they can go into the jewelry for that is going to which thing? Which type of design? Industrial design. Then how where that will go into which type of IT? Only there. Design also. Verify test all ITs are there. You take prepare apply all ITs. All ITs are. Now the metaverse they are putting into the shoes and you wear that shoes and then you can get the experience. That where the soon you will get in the market. Already in the malls, children are using that thing.
It's usually some
Can be language cannot be shared. Can be pop. Can be pop. So GI okay example, patent is okay, copyright.
The GI is okay for this one. GI is okay for this.
Because we costumes are there. Costumes. Then video it is trademark. That's still like copyright. Important. Important in the sense you will find it everywhere. Right? Then protection of plant varieties, farmers, right? Semiconductor integrated circuit design, geographical indication, and then there is the trade secret everywhere. You will find that in every collective. I've really been protection plant variety in farming. I will see fiber at it's the first skill you have told me. For this, you have told me three. Patent, copyright, and GI.
Trade purpose it can be used. For trade purpose it can be used.
Can be used for trade purpose. So example, dance. So solve just is running that, right? So that is a bit mark. Shamal Dawa Academy. Very popular. Right? Shamal Dawa. So these are the like marks. So even in your local places, some dance classes are very popular. Right? So they have their own trademark. They may have registered it, may not have registered. Only reaching the correctly registered. Amazon is very clear.
तो माणूस जे बिया करतो त्याला आपण गियायला डायरेक्टली आमचं गियायचं
हा नक्कीच मी फक्त तुम्हाला what I am doing now, my objective is very clear. I'm going to go through more maths. I just want to make sure that henceforth, whenever you can see any object, you will apply our identifiers. You will try to think in that direction, which I want you to apply to your project. Whenever some project comes in your mind, you have to first think in this direction. Which height is acceptable? Identify by the I will create out of that this also, this also, this also, this also, and I can differentiate. If I want to go for credit, I have to do this. If I want to go for copyright, I will go for it. So I am doing this. Then we will go further on the way. So I have given first you as a fabric. Different fabrics. Plant now you see some plant materials for a makeup. All this can be, in that sense, you can say that interpretation of plant material. So some materials, some costumes may be used specifically of some plant. Then that can be also used.
But plant is there, yeah, manufacturing stocks and towers by law.
Very good. So if trademark is there, and then solution plant variety work on that. They will be so trademark, copyright, patent, trade secret, industrial design, definitely will have that. Okay. So the trade secret will semiconductor secret. Something comes here. It's very difficult whether if I want to just page it, but if it's right this page, definitely that will come. Little bit space. I will move to the next one. Okay. Then Tirupati Laddu. Yeah, already there. Process is a credit. All recipes mostly trademark is also there. ITC है today Haldiram's है. So all these are the yes.
Common products.
Very class. So trademark is there. Already next.
Plants.
So protection of plant definitely it's like a plant.
Specific line.
Specific
line.
For example. अच्छा तो that is a trademark. So punchline जो बोलते हैं ना, so that is a tagline or punchline. That's a trademark. Then protect it.
उनका टैगलाइन में ऐसा कोई सगा नहीं जिसको हमने ठगा नहीं।
Oh. Very good बात है।
टेस्ट भी नहीं आ इंग्लिश सब
एकदम
ऐसा कोई सगा नहीं जिसको हमने ठगा नहीं। इतना मशहूर है सबको मालूम है।
Okay, so you have told me GI, then you have told me trademark, then trade secret, plant variety.
There is a street food Putare.
It's wonderful.
So that paper is prepared with a lot of time. made on the fire of coconut trees on a pot. Now the KVP of Amla Kendra, they are trying to make equipment which makes it much faster and quality control. Those older generation people, those skills are not being able to engage everything. Right. So they're trying to make a machine.
I also can like to communicate with the phone after it that the camera. So yeah, it's very difficult to do that. Any machine that you see, there if you know that we will back the machine now. Now you know that do some making machine now. Right, or such a baking machine. So part of your all this machines are patented by for
in ID card for all hospitals, routine machine.
Very difficult to use. Industry does.
That is cigarette. Not a great cigarette.
Because this is like how it works. So and all packaging. All packaging from the connectors. You see how nicely they are packaged. This is our ice cream products. Nicely they are packed. All this is necessary. Definitely. Process better and product. Definitely. Okay. So semiconductor, all machines is semiconductor. So in short, all ideas are right.
So the should make problem right. It कवर और को प्रॉपर अगर कवर तो चेक करना है
Now why red glass machines? Fluoride found. Now what type of activity? Then
unless you make product, how will you change here?
Agricultural products are also like all these are the agricultural products, and these are the agriculture, handicraft, and manufacturing products. So GI is possible. Trademark really is classic example you have taken. In Kerala, some brand is having like masala and that's spices. So there are some trademark is there. Okay, next. Mysore candle only. Plant protection of plant varieties definitely GI protection of plant varieties directly. Then this trade secret for baby, बहुत सारे trade secret.
इसमें कैसे लगेगा ट्रेड से?
हाँ, पता नहीं क्या है, अभी चलेंगे.
ट्रेड
secret, the food process. Spices will naturally add if you are creating a combination of different masala, that can be there.
combination of
Trademark is also. काला मसाला. Right. Yeah. If you take some of these examples, now why this have taken? Whenever you are creating pattern from the formulations using the plant materials and the animal products. So there are so many medicines. Ayurveda, so many medicines are mentioned. All these are prepared for the plant and animal. All this will go into the patent also. And you probably will get the separate library, traditional knowledge, digital library. Mention that all this. So all this Atharva Veda is covering all the medicine. This is like captured in the EKD library. And this is available actually. Everything is mentioned. This is because of this kind of Act, Patent Act is having some clauses related to this. What are clauses is that you are creating or using any natural resource, these are the natural resources, right? So if you are using especially pharma graduates, the pharma people, or Ayurveda graduates who are interested in law. So, so what will happen? That rule is like that. We have to take a certificate from biodiversity. Mandatory. If you have not taken the certificate from biodiversity board, your patent will not be granted. So it is a mandatory. Now there are some other issues are there related to this. I don't want to go into details of that, but with this lot of issues are lot of deliberations are going on how to fix that. That is not our discussion, that is not. This is a patent is possible, trademark is possible, only patent and the just going to trademark, trade secret. If you just take that thing, particular plant varieties, all the varieties can be get the way of except semiconductor, I cannot give that payment. All the varieties. Right? This is like to call them. I just want to emphasize that IPC. I've given you math, you make science. And then I'm just saying that IPC. In school we learn that air is everything. हाँ, it copyright नहीं चल रहा है उसके so whatever you are writing is a copyright. So copyright is by default. So, but this is something I always say. So this is I always promote in this way. I feel that you just say, see, now I just want you to look into different way after going through all this. To see anything, Suppose I take this, what type of IDs are? All IDs are all 8 types of IDs. That will be applicable. Tomorrow, if I cover it with a bamboo and all that thing, I can have clear. This is thing that stretch my thinking.
Association is a noun in the session of 2 hours session of the IPs. But then is noun again. Student questions are how can we now can be whether side of it. And the so already available. The master copyright is not regulatory.
Acha. No, see, copyright is for just understand and consider. This is story common as making us making videos. बाकी तुम्हें कुछ नहीं movie most of the movies 90% movies are this one. Hero, heroine, villain. Villain can be natural calamity, hero can be family, hero can villain can be the society. Different society can be villain sometimes, like all the same time. Sometimes we are in a Purana movie so what is copyright is for expression. Copyright is not using for content. The concept is wrong.
Literature is not right.
Copyright is for expression. Word for copyright is expression. Movie तुम्ही बाहुबली पण बघितले त्याच्यासारखेच दुसऱ्याकडून movie बघितले. But you probably I just see that the popularity of that, so I say that probably you like Bahubali much more. It is a way of presentation. Lectures have to be different, but you like somebody's delivery. Speech everybody gives. Content तो तोच असतो ना आपण. मोदीचं जेव्हा देणार तेव्हा प्रायव्हेट गांधीजी देतात तेव्हा किंवा राहुल गांधी देतात तेव्हा तुम्हाला इट्स युअर चॉईस तुला यू विल लाईक समबडी न्यूजपेपर मध्ये न्यूज सेमच असतं बट न्यूजपेपर फॉट फॉर कॉपीराइट व्हाय इज एक्सप्रेशन so don't this is a very wrong concept of copyright I will say Why? You don't like Times of India, you may like Hindustan Times. Right? Why? Because you like the way they have presented it. You like only one channel, you will not watch all channels, news channels. News तो सही नहीं है क्या? Content तो सही नहीं है. Why you are paraphrasing is a plagiarism की तरफ जाता है. It's infringement, copyright infringement. There is a difference. ठीक है? Paraphrasing many times we are doing in the many of our students. I will not say us. Many of our students are doing in the project submissions. They are doing it. It is our duty to stop that. Somebody told me that if somebody is doing that, it is a murder in America. Somebody is doing that plagiarism and paraphrasing and theft of projects, theft of research papers. We have seen this in even great example, very biotech professor. Yeah, it's a very shameful thing for academic actually. And there are some in my IT disputes and court IT disputes court practices and enforcement in that course have reported for use cases of copyright. I've seen one professor from South India. He has 70 plus publications and he was publishing like the number was very high. And generally when it was realized that he is being a copyright. University has taken action on him. They have stopped his research activity. Who teaching don't do this? That action they have taken. Probably somewhere he might have suspended it. So that is not accepted thing. The murder like yes. And copyright is only the same infringement, non-deliver offense. Non-deliver offense. It's like a equal to murder they have taken. Right? So it's very serious. So just understand that copyright is for expression. अमिताभ बच्चन चा डायलॉग म्हणलेला तुम्ही फिल्मांनी म्हणलेला आणि आपण म्हटलेलं expression is so copyright is for expression. लता मंगेशकर केली एक song मी sing केलं कोणी ऐकणार नाही. Right? So the thing is that how she sing that expression is very important. So copyright is for expression. Please understand. Content is there. Right? But we are not banging on content, we are banging on expression. Clear? Today, copyright is not my subject, so I will just focus on paper. But I just want you to say, if I take a rule, this rule. Now see if you can see IP here, intellectual property. You see the chair in which on which you are sitting. All types of IPs will get it. See your watch, all IPs are there. See your specs, all IPs are there. See your shirt or whatever you have, like saris and all IPs are available. See your pay, all IPs are available. Right? So I just want you to remember that IP is everything. You're walking through IP. Go on the road, you will see a lot of trademarks on those things. All names, all trademarks. Right? So we are surrounded by IP. Either you are using somebody's IP or you are creating. The IP is everything. Right? So this is the classification I guess probably in the morning this thing is discussed. So I will not go into details. If anything you want to know, I will just explain that. You just take it.
IPR protection and farmers what is
Absolutely, now later any procedure, but here use the grammar check or use it context. So that comes under the copyright of that.
Copyright question, but I will answer. Your question about the video plan. So it is a separate act. Morning like statement one, paracetamol 5 रुपए में मिलता है. So please understand. we should see the philosophy of this idea a little bit. Very crisp, I will just give you information. India background. In India, we have these 8 types of patents. In USA, if you go, there is a design patent. There is no industrial design. There is a design patent. There is a plant patent. Okay? We don't have plant patent. We have sui generis protection. Sui generis. This is a word used in the law. Sui generis. The meaning is like we have a self drafted law for the protection of plant varieties. So that was the option given to all countries actually we have chosen. Okay, so there was an international body TRIPS agreement is that you do not have to go that body. There is a TRIPS agreement going around, this happened and then if there was a guidelines internationally followed. Paris Convention is there. I guess you should not know about that history now. We are talking about patent. So the point I want to emphasize is that we opted to regional business. So we drafted our own law for the protection of plant varieties. We said that we will not give plant patent. We said that we will not give industrial design patent. We will give industrial design protection certificate. So we have to separate. Okay. The practical indication again. Our own regional system is that it is not like in every country. So they do trademark registration under that only they do protection. So these 3 acts, GI, this is the protection of plant varieties, industrial design, and then the semiconductor integrated. This is again regional system. So these 4 acts we have drafted. In India you will find that. In USA you will not find this in here. Right? So why this has happened? Because we don't want to give patent. This design, they will give design patent. We don't want plant patent, they will give plant patent. They will give that semiconductor patent. We are also giving patent, but we have a separate enacted act as well. And then the protection of plant variety we are going that through patent. Now, why we are not giving food and this medicine and this computer system, if you see. Section 3 जाएंगे now, section 3 में. So you will observe that certain inventions are not patentable in India. Okay, and this is a very tough, we can say section 3 for everybody. Outsiders के लिए very difficult. So I will say getting Indian patent is very difficult than the US patent because we have to cross all section 3 barriers. If we cross, then only you can get the patent. Otherwise, you will need to get that. USA, anything under the sun can be patented. I'm not saying this. This is the statement of the Diamond Chakravarti. In the Diamond Chakravarti, Diamond has given that statement. He's the judge from the USA. He has said that anything under the sun can be patented. That was his statement. We don't. We have a discussion. इसलिए वो नोवार्टिस का केस इतना हो गया, इसलिए वो मॉन्सेंटो इतना फाइट कर रहा है, right? We will not give that protection. Our system is very strong enough to protect that because they are trying to protect state sector. We don't give states land because our statement in section 3 is very clear. Plant or parts of the plant, they are not going to give the patent. Very clearly. They are thinking about the environment. We are so sympathetic towards environment. Anything which is harmful environment that is not protected. That reflects our philosophy in our act. So we are very careful about our act. And therefore we are living peacefully. If you see USA condition, farmers are so much the bankrupt food, so that is the scenario. Because with companies like this capitalization and all that is, they are like hampering the ecosystem, that economic ecosystem. Okay, so I don't want to go into details of that. I just want to focus here that these are the types protection of plant varieties because of that we have a
The patent only.
patent price you should have. Patent is not possible for that. It is a natural product. So discoveries are not patentable. Natural products are not patentable. Tomorrow, if you find a new planet, you cannot say this is my planet. This is a discovery. Tomorrow you find some microorganisms. You cannot say this is my microorganism. You are already there. You discovered it. Discoveries are not patentable. patent planning क्या variety करता है? क्या variety पे register करो शामिल trademark register करना और patent plan. Patent is very dangerous. मतलब whenever you will get a patent rights, these are so many rights are there. Make, sale, use, make, sale, offer to sale, manufacture, use, offer to use, import, all these rights are coming. Seeds पे असेल तर ते एक तर seeds natural specific product असेल geographical indication मध्ये नाही किंवा मग त्याचं तुम्ही प्रोटेक्शन प्लान करायचं का त्याच्यामध्ये you are getting the protection. You are getting good protection to that. There are good examples of protecting wheat grain, wheat variety. You can create that new variety. You can protect that. There is no problem. I will tell you this question. I can clarify. डिफरेंस क्या है पेटेंट एंड हमारा दिस है हमारा प्लांट वैरायटीज जो एक्टिव हो क्या होता है 10 टेस्ट करना है 10 टेस्ट इज व्हाट मोनसेंटो का सीड हम नहीं कर रहे अलाउ नहीं कर रहे व्हाई बिकॉज़ दैट विल गिव क्रॉप ओनली फॉर मंथ्स उसका जो सीड आएगा वो क्रॉप नहीं देगा कैन यू इमेजिन दिस इज द सिचुएशन टर्मिनेटेड सारा सो नेक्स्ट जनरेशन पॉसिबली नहीं है. Next generation, you have to depend on company for that state. Farmers variety में 10 test है. इसमें क्या है? कि they will check whether you have used terminated gene or not. If you have used it, they will not allow it. But hybrid मध्ये I'm not like exploiting that, but maybe. माझी बड़ी सिंपल मध्ये काम करे. टर्मिनेशन होतं आणि पढ़ाई हायब्रिडचं होतं ते लगेच नाही याच्यामध्ये किती ते लगेच तुम्हाला you have to be dependent on that program actually. So here naturally this is happening. This is a natural process. Here they are creating it up. And therefore dust test is there. So if hybrid variety is there, probably if it goes to section on that dust test and if dust test is not qualified, that will not be very simple. Okay, so that is the situation. So they will have the variety, but they will not get protection. That is.
What do you mean intellectual capital?
Intellectual capital actually, if I want to give two aspects are there for intellectual capital. One is like a financial aspect, one is like an intellectual property related aspect. You know, so I will just give you in this context, I have taken this as a intellectual asset related asset. What it is actually. When you talk about the capital, intellectual capital, if I want to put into the crisp rate, I will say that there is a human capital, relational capital, structural capital. These three. For example, if I take this university only, up to basic, right? So if you say this university, what is the intellectual capital of this university? Suppose I want to do. All faculty, all students, all lab personnel, and all stakeholders, all this is in human capital. Structural capital, all this infrastructure, whatever we are saying, all this will come in the structural capital. All building, car, and then machineries, labs are there. All this will come to structural capital. Relational capital. Now they have like a MOUs probably with other universities, foreign universities. Now they have invited like us here, so you will create a relationship here. All of us came here, we are building a relationship here, we are sharing knowledge. So that is relational. Next is like a cognitive capital, cognitive capital, and capital. So what is a cognitive capital? Cognitive capacity we are discussing. So bodies are there saying that AI has cognitive capacity. If we can build, AI will be like a AGI we was talking about, right? So this cognitive capability is our own capability to reasoning and processing things. Right? Cognitive capability means whenever any problem statement comes in front of you, every person have a different processing time. How to solve that problem, everyone have a different process for it. So that is what the cognitive capability. Affective capability. Affective is what? Passion for that particular. Something we are doing because we are passionate about it. right? Classic example, Steve Jobs, very passionate, so that this kind of computers are there, which we are using, right? So that affection is, otherwise you will not, you want to, at least for this FDP you came because you want to learn something, you want to know IP, you want the opportunity, you have sanctioned all these links and all that thing and you are, right? Because you have a passion for it. You thought that is something, some learning will be given. So that is affection. I give a classic example of that Volkswagen car ad आता था. Now that ad is not coming, but that car is going outside the factory, and the scientist or engineer who is working, he feels so nostalgic about it that my creation is going away from me. Right? It's a very classic example of a passion. Why in Corona time many scientists are ready to give their life for the drug development? Many have tried. Many scientists have. Why? Because they are passionate, very curious, classic. They know it is dangerous, but it is a passion. So that is what the intellectual capital comes. We know there is a danger, but still you are ready to do that because it is your passion push you to do that particular. Socrates was going, I am going to die. But he was ready with the pain and pain very that he wanted to drink that poison will be given to him. He said that I will write down about it when I am time. So see the passion of the learning and sharing. Right? So when we are talking about this intellectual capital, it is a structural capital, relational capital, then human capital, cognitive capital, and then affective capital. All together forms the innovation capital, and that innovation capital creates a.
All IPs can be considered as
All property. We will consider it as a property. Whenever I start class in the third year, because I used to look relatively third year, they have already learned something about IP and then they come for IP management. And I always ask first question to them, what do you understand by intellectual property? What do you understand by intellectual property rights? What is the difference? Whether I should say intellectual property or whether I should say intellectual property right. Just now you have said that whether I should say intellectual capital to intellectual property. Intellectual capital is a giving me IP. The tool to create IP. Intellectual capital is which is creating the intellectual property. Now, whether intellectual property and intellectual property are same, no, they are also. Just think about it. You find answer in the last few weeks. If you don't like, no, so definitely able to understand the analysis. More detail or after 2 minutes. After 2 minutes, you will finish.
What is utility patent?
Utility patent is only in the USA and China. We don't have utility patent. So, what is the difference there? Our normal patent today, what we are having is a 20 years timeline and stringent processing of that patent. Utility patent is stringent processing. Examination is very what we can say. There is no that rigorous examination is not there. And the life 7 to 8 years. So we don't have utility patent in English. Okay, but USA and China, they have utility patent. Again, I want to just say that many times you see the number. USA have 3 lakh patents. China have 5 lakh patents. Right? Yeah, USA always say 600 patents every week they are filed. There are more utility patents also. We don't have utility patents. So we do not worry about our number of patents in that number, but we have to worry with it. 140 billion and 1 lakh patent is not matched. That we have to do. We don't want to compete with 3 lakhs and this thing. So there are utility patent, but 140 billion and 1 lakh patent is not a good number. So that we have to take. Okay. This okay? Any doubt? He was talking about a copyright actually. Paraphrasing will say something to you. And then grammar is checking actually. And grammar is checking and then paraphrasing.
Just we have written as per our mind that for including the grammatic grammar. That
Grammarly using there is no problem. There is no problem because your text is clear, content is clear, And then you are just correcting it grammatical. Absolutely, we require that. We are English is not our first language, so we should use that. There is no special topic. Chat GPT you are using at that time probably what is happening, cognitive issues are found. But that is another issue. So I will not go into details of that. But that is another. ठीक है Second, अच्छा अच्छा. This trademark, there are different types are there. So certificate mark, मतलब example I will give you. Trademark is there, right? Yeah, I there. Mark is there. Filth mark is there, right? Khadi mark is there. So what it is? There is a problem with these things. We are getting a adulterated products in the market, compromised products in the market. So these agencies are there who are certified. So these are the certificates. It can be government agency, it can be non-government agency, ISO, non-government organization. Huh? Yes. So you know, so go ahead. Okay? What about well, for example, if I take few names like Tata, Ola, right? Amul. Almost everybody in India knows this. So the marks which are known by the larger public, it is called as the brand. Collective marks is like a, if I say example, PK is a collective mark. Because it is a, many of the industrial organizations, companies are coming together and they have their own like body, which is taking care of interest of all the members. So PK has CII, collaborative. So that is the collective. Even Amol sometimes says it is a collective mark because it is a cooperative society. Classic successful example. You keep it covering you can you can give, you can yeah.
Geography like geography, the geography. Like something. Geography. Oh, so I mean, like,
Two questions are there. What is the difference between trade secret and trademark? And another question. If I do Pashmina shawl, this that specific sheet is there. If I take it to Maratha or some other place and if I do production of that, either that is allowed or that will be come under geographical indication. So first actually trade secret and trademark. Trademark is like a altogether it is a for identity. If I want to give one word for trademark is identity. Exactly. I tried it two names. You just imagine in front of your podcast. Tata, Bata, Mochi, West Side, then Nakshatra, Reliance, Times of India. Two things come in front of me, right? Now I say two other things. That specific composition for medicinal products. I can cure your any disease by just giving you a certain tablet. I can develop a purification system, water purification. I will just add something in water and that water will be purified. So Ganga Ji, 60 crore people are taking bath, but still Ganga Ji is like pure. Why? There is a great secret. Just think about it. There is actually this thing. Why Ganga is so important. Bacteria patches are there in the naturally. Naturally in Ganga water there are bacteria patches. So because of that Ganga water is always pure. And therefore that is the science behind that Ganga water. So why we are given importance to Ganga? No any other river have that kind of a problem. But Ganga water have that bacteria patches naturally it is there and therefore that water is pure. So 60 crores we let it go, that is capacity now because of water pollution, I don't know, but that is the natural capacity of cover. Okay, and therefore when it's like a biscuit like clean water, actually, if it comes from the that starting point in the mind. Is that clear? Because no microorganism can survive in the that was the so this is a secret we probably were not knowing, and it is put into that religion and all that thing or something like that. Because we are giving importance in that. So few names, whatever I have taken first, it is example of a trademarks. identity. Reliance, probably somebody had thought about Ambani, somebody had thought about like Reliance Fresh and all other things. Right? If I had taken Tata, somebody might have thought about Ratanji, somebody might have thought about Tata Salt, somebody might have thought about Tata Nano, right? So what happened? One person is giving identity. That is a trade. And trade secret is something which is secret related to trade. Secret to सबके पास. We are not talking about that secret. Everybody has secret. We are not talking about that. Trade secret. Trade related secret है if that is disclosed, but trade will be active. Right? So something like formulation, I have given a formulation. You have to take that water will be purified. Yes. You can do it is your choice. You have to give patent, you have to take patent, or you have to keep it as a case. That is your choice. Now you have to just tell. I have given this is the first exercise here. Identify 8 items. Now it is your choice. Whether you will go with patent or trade secret or trademark or you will. That is your choice. You have to build your portfolio. You have to build your portfolio. Right? That is it. Here, difference between trade secret and trade secret. And trade secret का case court में जाता है तो judge कैसे होता है? Judge will first check whether it is really or trade secret. How do you check that it is a trade secret? It should be related to trade. If it is disclosed, there will be the it is affecting its confidentiality. So, owner has taken sufficient measures protects the confidentiality of that case. My trade secret बोल रहा हूँ, but I have not taken any caution, so that cannot be received. So I have to prove I have taken sufficient caution, but that fellow has taken the infringement. He has told that is a problem. So to prove that, I have to show that whenever I am communicating with him, I have taken a sufficient caution so that it will be in a secret. But this fellow can publicize it. Then court will take action. Okay, so that is the case. Trademark is very general. A lot of trademark cases are. There's a very popular case, Starbucks and Starbucks. Very popular case. We will not go. We are not purchasing it. Especially the short example. So geographical indication not the indication of that geography. इसीलिए तो geographic indication. नाम क्या है? Geographic indication. Indication of geography. Kashmir का indication Kashmir ना था. That ship you will find only in that weather, that tradition only. Alfonso mango, देवगढ़ में भी होगा, वो प्लांट लाके में महाराष्ट्र में भी लगा सकते हो, any part of that. But if you see the quality, I also brought from Deoghar that time, and I have put in my Karate project. It is growing nicely, but वो taste नहीं आता. Deoghar का taste and Karate का taste. There is a minor difference. So in this vegetable, that difference is definitely. Why? Because weather conditions, soil conditions, all are affecting the. That is very good. So, Pashmina shawl का sheep लेके आप देखे जाएंगे, probably that sheep will not survive. आप sheep को छोड़ के खाली उसका hairs को लेके चले गए, if you try to develop that, probably that quality may not come because these people are doing it because family business. So there will be that difference. Duplicate होगा, but originality जिसको पता है, they easily realize what is the difference. Collaborate Chakkal Bay. Many are like developing it in Mumbai. You are getting Collaborate Chakkal in Mumbai. So the point is like it is a duplicate. So that they cannot call it as Collaborate Chakkal. So geographical indication that they cannot use only Collaborate people can use that GI. That is very important. Yes. Any other doubt? So what is the reason? I will just give you the this thing tip to you. If you are going for patent, please file product patent. Don't go for process. Want to file a process patent? You will file a product patent along with it plus process. Only process patent enforce करना बहुत मुश्किल होता है. You don't want to enter into litigation firstly, and if you go into litigation, you have to prove that burden हमारे ऊपर है. Then it is very difficult to prove that process. Okay. You cannot visit the factory inside without permission. There is one process for that, but that is the court process. That is possible, but there is another process for that. But that you cannot go into anything. So better they have a product patent, it will be the market and you can directly have like proof. So it is better to have a product. Product is like a final product. So for example, footwear. If I take how to prepare that footwear to see if a patent will tell it, but match it with the product. So you should have a product and process patent together. That will be better to use.
What about the masalas?
In that case. So if you would able to take a product patent on that also along with the process. So we have best home position for patent like that. एक ही भी करने हैं खाली ड्राफ्टिंग करने तो केवल टेक अ क्वेश्चन दैट्स you need not go you will not get different patent it will be a one patent only but you make sure that you bang on both first product and then process that will be good. Anything else?
So the new chemical is proven to have some properties and go for patent. It is possible that somebody else might satisfy the same for different process.
Possible, 100%.
So when I am filing for protection, I am aware of my process.
You are not aware about another. So you have to protect your product.
You will protect my product even if somebody else invents n number of processes.
That will be patent. In number of processes. Now, how they will get a patent product? So if they have a different process, they have to show it is different from your one. That is one thing. But survival in the market, if I want to do the commercialization of that, they should have efficient process and your process. क्या आपका 10 रुपए में बनता है तो उनका 1 रुपए में बनेगा तो ही they will survive. They are allowed to get process, different processes are maybe in ideas. If your process is of 10 rupees, he may have 100 rupees, that is 20 because it's in the category.
So the fact that I have invented this chemical first time doesn't mean any protection.
You will need protection for your process to your product. Now he will not bang on the product already you have patented. He will bang on the process. So he will say that I have a different process. Okay.
Suppose I have invented paracetamol and I have manufactured my process again. After somebody has applied for patenting a different process. But again, he will say the paracetamol. So he might get a patent for the process of patent the paracetamol.
So related to the paracetamol का example I will paracetamol generate कर दूँगा. तो उसका different processes are there. Okay, process different. Product patentable है नहीं. So he may have a patent, but we use chemicals. Investment technique for that, yeah. So he don't think we want so it's like it is an investment of 1.25 lakhs का investment होगी. Use share market में छोड़ दे. IP is for a commercial right. Financials का improvement. That is very important.
Question. Patents expire 20 past date. आज परत असं नाही करायचं मी त्या पेटंटची कंपनी त्याच्यामध्ये आणखी काय ऍड करा 99.99 तेच कंपनी 0.1 ऍड करा परत त्याला परत केलं ते ऍप्लिकेबल
Section 3 not otherwise. Section 3
म्हणजे काल संपला आता थोडं
philosophy kind. Every IP is like having a limited time. Why? Because it should not be so good. US will allow us. US में इसको बोलते हैं evergreening. Evergreening of patent is allowed in US. In India, it is not allowed because of section. Section 3 says that no use of substance, mere replacement and replacement of the molecules are not allowed to be patented. You are not replacing it. In that, you are adding one thing. It is not patented. What you are patenting into everything.
Yes, sir. US में अगर अप्लाई करना है
US वाले बोलते हैं US में allowed है because they don't have section 3. We have section 3.
प्लीज सीरम मेंटेन करके कैसे करना
Hello.
yes sir
No, 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 everything under the sun is possible.
क्या सेंस है अवेलेबल है
Yes, the green curve.
हाँ yes सर पर आप अगर यूज करते हो 1% चेंज नहीं है 99.99 आपसे
So it is not allowed.
Even we should try agree.
नहीं, two different ऐसे नहीं करना. Same masala, you will have a same product and only one patent. But you will ban one product. Bigger process. तो उसमें क्या होता है कि whenever we are drafting patent ना, we have a dependent claim and independent claim. आपका independent claim product का होना चाहिए, dependent claim process के. या फिर process का independent रख सकते हैं सिर्फ. तो जनरली हम claim ड्राफ्ट करते हैं तो 3 independent claim रखते हैं और उसके ऊपर फिर 2 हमारा पेटेंट पूरा तो नहीं जाता बचता है. पार्ट की अमेंडमेंट के साथ.
चलता है तो हमारे सेंस को
हाँ तो समटाइम्स क्या होता है कि इंडिपेंडेंट क्लेम अगर कोई एग्जामिनर जो बोलता है उसके ऊपर डिपेंडेंट जो है ना तब निकल जाता है तो भी डिवाइडेड ऑप्शन करके पड़ता है. इसीलिए वो क्लेम हम प्राप्त करते वक्त लिखेंगे. So whenever you are giving into any independent direction, make sure he is taking all these options. मतलब दो तीन ऑप्शन है. Whenever client comes to me, I just ask him to see patent. You should write your invention only in 4 lines. Because we don't do anything much like greater. We are not doing disruptive innovation, frankly speaking. We are doing incremental innovation. So you should be able to write in 4 lines. क्या किया है? Inventive step क्या है? We want inventive step. If I know inventive step, that goes me easily to do the patent search. After doing patent search, if I get confidence कि grant होगा तभी मैं drop करूँगी, otherwise I will not go for that. I will give guarantee this will be 100%. This will be granted. Only 1% I cannot give guarantee because by 18 months का gap रहता है application. So first you should be able to write your invention in 4 lines. Second, the patent search should be positive. And then the important thing is always there is some trade secret in it. Always. So I will just ask my inventor, what is that one thing if I will not do, your patent will not work? What is that one thing which will not, which is important, and if I will not do that step, your patent will never work. Then he tells me that particular. And I will never disclose in my patent that will be secret always. As a caution, I will never disclose that. So I will follow the rule of statutory rule, 100% disclosure. That is a rule patent file company. Statutory provision. You should disclose your invention, then you are getting the grant. So I'm disclosing, but I'm not disclosing that one thing without which my patent. So you have to make sure that your agent will take that function. And drafting should be proper, especially claim. So that function should be taken. Strategy to be kind. Unit of invention is concept. Unit of invention. Sometimes core claim के रेशियो में the invention complete is sometimes. Unless I give details of that 4 things, I cannot able to draft that way. So one claim के लिए I will not do that. Okay. So unit of invention, I should disclose everything in that one patent so that that product can be done. That is mandatory. If I will not able to do, examiner will not allow granting. That is mandatory. Second thing is how much money you आपको पोर्टफोलियो बढ़ाना है या आपको पेटेंट क्वालिटी बढ़ाना है? पोर्टफोलियो बढ़ा के भी क्वालिटी बढ़ा सकते हैं। मतलब मैं एक पेटेंट independently, properly, अगर मैं you are saying 10 में probably I don't think there will be like many possibility, but you can have a two claims each. नहीं, generally my observation नहीं होता है। 20 claims पे possible है, मतलब if I patent नहीं होता है। I tell you क्या होता है ना, your invention, at least small invention also I will take at least time to develop find within I will never इसीलिए तो मिनिमम का गवर्नमेंट का ही है कि 10 ईयर मिनिमम होना चाहिए, मतलब पैसे एक्स्ट्रा नहीं ले रहा है। गवर्नमेंट ऑफ इंडिया आल्सो रिकॉग्नाइज कि देयर आर 10 ईयर्स, नो एक्स्ट्रा कॉस्ट इज देयर। 10 ईयर के ऊपर जाता है तो एक्स्ट्रा कॉस्ट। तो जनरली तो एक्सप्लेन मानते हैं कि आई टेक 5 ईयर्स नहीं, तो उसमें एक स्ट्रेटजी रहेगा गेम ड्राफ्ट करने का। जितना मैं अच्छे से गेम ड्राफ्ट करूँ उतना मेरा चांसेस ऑफ living my all the features, so I will take the opportunity. I will not go for more patency. A very complex patent is there, very complex रहता है. So I have to see कि I will not hamper the product. So I just remember the case. There was one very complicated product. बहुत features थे. Still I have decided that I will have one patent. Because without that I am not getting that full picture of that invention. So it depends. So it's a call on that. What is exactly a transition? So I cannot give you blanket answer for this thing. You can do it. But I will recommend at least use that 10 years for one nice thing, nicely drafted, cleverly drafted, so that it will be granted.
10 seconds में money. तो 10 seconds आपका
अच्छा बदल नहीं कहा था
10 seconds क्या है ना?
आता नहीं सकते
टाइम में काम
हाँ नहीं सकते एक मजे का इन्वेंशन आने लगता है क्लाइंट्स
एक डिस्को बैंक फॉर के वाला स्टेप
नहीं कसले तरीका असतो ना. So what you have to do here, he has created an invention related to RO, reverse osmosis of machine he has created. And then he has given all information about that. And he said that there is one chemical, I will not obviously say that chemical, I know that. But that chemical is there and you will add it into that water along with that machine. Your water will be 100%, will sea water will be converted into the proper like fresh water. So I was knowing that what product is there. So what I have done for that particular material, I have used very broad terminology, so that nobody will recognize that what is there. I have given information that I have used this particular thing, but I have not given exactly what I have used. Now why I have not given it was, as I said, patent is for verification. You are developing patent. एक जो ट्रेंड है ना अर्ली पब्लिकेशन, आई विल नेवर से गो फॉर अर्ली पब्लिकेशन. पेटेंट जितना छुपा रहे उतना अच्छा है, पब्लिकेशन जितना ओपन रहे अच्छा है. रिसर्च पब्लिकेशन you should like put on social media and everywhere and all. Patent you should never put on the social media. If you ask me now, we are getting grant money and all that, we finish. This is never able to develop a criminal activity around. Not possible. Because somebody will check it, already they do little modification, they will move on and continue. You will never able to do that. So अगर if you are really entering want to enter into the criminal activity, जितना छुपा के रखो उतना. इसीलिए whenever you are drafting patent, we don't say patent is related to paying something. So we never say pay, we say writing device. So we have to keep it very broad and not fetchable possibly. So we should never disclose our patents. We are future, in future we are creating the business. Don't publish that. That is the caution. These are the different ads section which are related to IPR. So it is a statutory provision. Okay, that is very, very important. Huh? Patent, Copyright Act, Trademark Act, Design Act. Okay. See this example actually. We should have patented yeast in 1873. Long back. Actually, microorganisms are not patentable. Then 1980 का case हो गया Ansari Chakrabarti. After that, we are able to protect microorganism. Yeast तो fungus में जाता है. So technically in India it will not be protected. It will be protected only in US because in US the policy भी protect हो गया था. Amphomice भी protect हो गया. Amphomice you mice, right? So new mice is Harvard mouse. That is a patented product of Harvard University. Sure, township you know that is artificially created, right? Yeah, technology. So this is the classic example actually. Tag polymer is the classic example. Corona के time में everybody have used PCR. We should thank Dr. Willis. PCR technology he has developed that because at that time PCR technology was used to detect that virus infection, right? You see the revenue generation out of that. Optimal large $300 million out of that tag polymers they have created at that time, in 1980. So lot of revenue generation with one patent. So said no morning, check the definition of property. So this is property. What exactly property is? It designates real or intellectual good that are commonly recognized in rightful possession. Huh? And what exactly you can do with the ownership? You can control, benefit, transfer, or exclude. So if this is my bungalow, I can decide who will live there, whether I should rent it, whether I should sell it. Similarly, just remember your patent if it is there or in any of the IP, you can rent it, you can license it, okay? Then you can like sell it, you can give it for the manufacturing, just as Serum को मिल गया था Corona का vaccine, they have received license for manufacturing, right? So all these things are possible with the patent, right? It's a property. Again, that is intangible and yet tangible. So whatever you can do with the land, you can do with the patent. Simple. So very powerful property. I can give you an example. Michael Jackson, Michael Jackson now जाके भी 4-5 साल से ज्यादा है, right? Till date, until now next 60 years, his family will get how many months? How much money? Can you imagine? $8 billion every year. They are going to get because of the copyright. $8 billion. So his big family actually 11 sister brothers. So all this family, I was they will get that $8 billion every year from that copyright. That is a power. That is what the power of technology, right? It's very interesting. So if we have one patent, we can create that whole empire begins. So patent can have three parts: searching, crafting, and the litigation. These are the three different things. If you have to go into the searching, you should be putting the subject. So generally, for searching in the offices, generally documents are at least masters. Right? If you want to go drafting prosecution, you should be patent agent. And if you want to go to litigation, you should know law. So law degree is mandatory if you want to practice in court. Lawyers cannot practice in patent office. Okay, so patent agent is important. Okay, so that is very important. So these are three different fields are there. Okay. This is the certificate, one certificate that the patent is granted. On this, you will see not many patent certificates. This is the publication. What happens automatically? At the 18 months, the patent will be published. Right? Once it is published, you cannot do anything. You cannot withdraw also. It is already in the public. So by mistake, if you realize later, the 17th month also, that I don't want to go proceed with that patent, withdraw it immediately. so that it will not publish. 18 months you cannot stop, it will be automatically published. Okay? So these are the parts of a patent. Probably if you have seen the patent, that document is there. You can see. So if you see the patent document, research paper have a standard format. Abstract head, then introduction, then you are giving literature review, then you are giving that material methods, your results and discussion, then you are giving the conclusion. Ekdam standard. You can take any of the research. Similarly, patent, you take any patent, any country. This is the form. Okay. So there will be a title, there will be a background, there will be a grid of the invention, there will be a summary of the invention, there will be object of the invention, there will be the description, there will be drawings if it is there, and the claims. Okay. So this document you can take in a group like 3 or 4 people, one document is good enough. So I have given you this simple document, very simple document it is. Just understand how to read the patent. Because patent reading itself is little tedious actually. It takes time. I have listed 3 lectures of almost 1 hour in that program for patent creation. How to read a patent actually. Because it is very, if first time you start reading that, I just share that. One of our clients was there. He given LTPC scientist. They have given the invention to us. We have drafted it. FDR, the first examination report aa gaya. So we just have a meeting with them. They themselves came to the office, otherwise we do online. So we were discussing. We have given him patent, whatever we have submitted. He was so confused. He said, "What is this? We have not even understand." So that much difference happens. What the inventor says and what actually done. So this is very tedious actual document. You may not be able to read in one go. If first time you are reading. Just remember first experience of reading this paper. Till some same experience you will get with first time you will get patent. Maybe आता समझे you should not get like a board कि हमारे patent पढ़ना है ऐसे. You should not. You have to sit for at least 10 hours. Then only you can finish up the patent. Because don't go one day. Patches में चलो. 2-3 दिन में आराम से first patent finish हो सकते. Once you do that, then you become master. Because now we read 1,000 patents very easily. 10,000 patents easily. Our students also read. It's a fact. Nothing like that. Great. But first patent is always there. Okay. And this format is very good. Format is very good. Next. Patent के कुछ types हैं. I will not go much into that because we want to focus on practical. Fine. So I will not go into this details of time. We will just go directly. These are the 4 patent offices that I have. Dependent. Claim seeking में आता हुआ हो सकता था मुझे तुम्हारा 1000 पेज से लेकर डॉक्यूमेंट ठीक है so there is no restriction on claims. So there are 4 offices in India. Whenever you are filing patent, you are filing in these 4 offices: Delhi, Mumbai, Chennai, and Kolkata. Nowadays everything is online. So we are showing you the patent filing procedure online. So I will not touch that. These are the 4 patent offices in Indian jurisdiction wise. अब ऑनलाइन भी करते हैं तो ऑटोमेटिकली नंबर्स है दिल्ली 1 है मुंबई 2 है चेन्नई 3 है और कोलकाता है 4 है तो ऑटोमेटिकली वो नंबरिंग हो जाता है ठीक है and the jurisdiction is given automatically whenever you put the address immediately it will be recognized in the number action so number देख के पता चलता है from where this patent is from कोडिंग है what can be patented process of method can be patented machine apparatus article of manufacture composition and improvement that can be patented now this inventions which are This is very important section. So frivolous and claims anything contrary to the natural law or contrary to the that is the perpetual question. Not possible. Right? Natural law के against that cannot be repeated. Next, contrary to public order or morality. If bombs है या फिर dacoity, question of dacoity, that cannot be. Mere discovery of scientific principle or formulation of abstract theories not here. So discoveries I have told you, scientific principle is equal to MC square. Very classic scientific principle, but that cannot be patented. Abstract, something in abstract if you are saying, that is not patented. Ideas are not patented. That नहीं पूछ सकते पर इसका केस है रबर केस प्रोसेस त्याचे केस रबर टेक्नॉलॉजी रिलेटेड वन केस हो गया so by using mathematical expression you can design the lab programs laboratory में जो programs बनते हैं तो वो mathematical formula based ही होते हैं तो you have जैसे software also is not patentable तो software coupled with the hardware is a patent. Similarly, mathematical expressions used for the creation or any process or a product combination नहीं हो सकता है. Like rubber production का process right now is not built. That is the very first case where mathematical expression is the product, but along with the process. त्याला काहीतरी process म्हणजे rubber ते whenever that or the plant that using of mathematics that is converted into rubber from bulk. So that vulcanization related process is patented because of that mathematical expression only they are able to do that. So software along with hardware patented, mathematical expression along with the thinking that product is a best. Now just C is equal to x square plus how many things are products. Base everything. And this is a technology university. So they will use all basic concept for creation of technology. So you have to go about technology. Expected. Now let's see, this is very important, whatever we have been talking about. We have discovery of a new form of a known substance. Classic example aspirin. Aspirin previously headache के लिए use किया जाता था. Sorry, next minute. New form of a known substance, ये आपने दिया हुआ example. Existing में modifications and all. Enhancement में कुछ change नहीं. Enhancement में change होता है, then accepted. You said that no change नहीं. Right. Mere discovery of a new property, the classic example aspirin. Aspirin was first used for headache. Later, they realized it's the blood thinning property. इसीलिए पेटेंट नहीं है. Now you see, 5 रुपए में वो इकोस्प्रिन मिलता है. 5 रुपए में 10 का स्प्रिन. आपको डाउट होगा इतना सस्ता है. But that is a fact. Because दो पेटेंट. नाही म्हणजे एक सबस्टन्स आहे त्याला एकच पेटेंट मिळणार. एका वेळेला तुम्ही किती जर असेल तर ठीक आहे. म्हणजे आज मी फाईल करताना अँटीसिपेट मी बऱ्याच वेळेला क्लायंट माझ्याकडे मी एक एक्झाम्पल करते. वेस्ट रिलेटेड एक पेटेंट होते एका क्लायंटचं. तर खूप छान इन्व्हेन्शन होतं की विदाउट ह्युमन इंटरव्हेन्शन कचरा त्यांनी नुसतं त्या ह्याच्यात घातला मशीनमध्ये की ऑटोमॅटिकली बायोलिक्विफिकेशन व्हायचं. ऑटोमॅटिकली सगळं बाकीचा इव्हॅल्युएट मटेरियल वेगळं व्हायचं. तर ते फक्त त्यांनी बेस्ट प्रोडक्शनच्या दृष्टीने दे थॉट अबाउट इट. And I said, hey, this is good in food industry. I just asked him, and he said, "Ah, yes, also." So then we have to think. As a third person, I have to give the idea. Then I have to write it in the claim that this will be used in food industry.
Patent format, in the regulation, then you can mention multiple things.
You can mention. Definitely you can. Or you can give a broader.
मी म्हटलं तरी काही फरक नाही पडत, नाही म्हटलं तरी काही फरक नाही.
ऍप्लिकेशन पेटेंट करायचं म्हणजे
ते म्हटलं एक पेटंट आपण एक्सपायर डेटसाठी काही केलं. तसं दुसरं काहीतरी ऍप्लिकेशन
नाही. मी आता माझ्याकडे आज क्लायंट आले ना, आज क्लायंट मला काय म्हटले की बेस्ट ट्रीटमेंटसाठी, पण मला त्याच वेळेस लक्षात आलं की अरे फक्त बेस्टसाठी नाही, तुमच्यासाठी पण
पण तरी पण तुम्ही
नाही. मी ते दोन्ही क्लेम करणार नाही, एकाच क्लेम करणार.
ऍप्लिकेशन दोन बरोबर आहे. तुम्ही क्लेम केलं, मला माहिती नाही म्हणून, पण एखादा असं तो क्वांटिटी तुम्हाला माहिती नाही त्याकडे यूज होतो.
हा,
त्या केसमध्ये
पण घेणार
आपण ऍप्लिकेशनसाठी पेटंट घेऊ
नाही मिळणार. पण डू यूज ऑफ हिलिंग सबस्टन्स ऑब्वियसली म्हणजे नाही, सेक्शन 3 मध्ये जा. नाही नाही, तुमचं कन्फ्युजन झालं. Whenever I'm filing, I will keep raw. आज मी फाईल करताना सांगणार की माझं ऑटोमोबाईल पण एक्सप्लोर, ते माझं वेस्ट मॅनेजमेंट मध्ये पण म्हणा, ते माझं फूड इंडस्ट्रीमध्ये पण अप्लाय होतं. हे मी खाली 10 प्लेन घेताना आणि मला 2 द्यायला तरी चालू आहे. एखादा जाऊन गेला तर मी आय हॅव मिस द बस.
तो एकदा सांगून ठेवला त्याला दुसऱ्याने केलं
होऊ शकत नाही, कारण काय पाठवलं तुमचं मग क्लेम करू शकत नाही. तुमचं नुकसान होतं ना. आज असं तुमचं पेटेंट असतं, साधा एक्झाम्पल बघा. पेप्सीचं एक तुम्हाला उदाहरण द्यायचं. पेप्सी कॅन आहे ना, पेप्सी कॅन एका टीनेजरने डेव्हलप केली. 18-19 वर्षाचा मुलगा असेल, पेप्सी कॅन डेव्हलप केला. त्याने कशी स्कीम कमर्शियलायझेशन स्कीम कशी लावली बघा त्याची. त्याने असं नाही सांगितलं की मी तुम्हाला देतो, मला 2 लाख द्या, 10 लाख द्या, 50 लाख द्या, काही नाही. त्याने सांगितलं जगामध्ये जितकं wherever in the world this can be sold, 1 penny should come to you. माझ्या माहितीप्रमाणे 1 लाखपेक्षा जास्त कॅन एका दिवसात जातात. एका दिवसात मुलाची कमाई किती झाली असेल. वाईज कमर्शियलायझेशन, वाईज नुकसान किती होते बघ. एक तो माझा क्लेम आजपर्यंतचा विसरला तरी 5 रुपयाला आहे. 50 रुपयाला जरी 10 रुपयाला विकली असते तरी 5 रुपये मला मिळाले असते. किती जण खात आहेत असं, थोडं नुकसान नाही झालं. हे पेटेंटचं कमर्शियलायझेशनचं थीम. So if you miss something, you miss. You lost. Okay.
त्या प्रॉडक्टचा त्या प्रॉडक्टचा आणखी यूज आहे.
थर्ड यूज आहे, फोर्थ यूज आहे, सगळे यूज तुम्ही काही करू शकता.
पण ते मी आता
नाही करू शकत. काय असते हल्लीचे मी प्रोडक्शन कॉम्पोजिशन करतात, कर्क्युलिन घेतात आणि कर्क्युलिन विथ कॉम्पोजिशन पेटेंट करतात. किती कमर्शियल आहेत सगळे सांगत आहेत. सगळे रिसर्च पेपर सारखे पडून तसं पेटेंट बरेच आहे. 2% फक्त कमर्शियलायझेशन रेट आहे, 2 to 5%. एवढाच रेट आहे पेटेंटचा कमर्शियलायझेशन.
आपण क्लेम करायची रिसर्च होतो तर पर्टिक्युलर माणसाला बाहेर बेनिफिट नाही मिळत त्या पर्टिक्युलर गोष्टीपेक्षा, पण दुसऱ्याला पेटंट नाही.
मग त्याच्यात आणि केले मला तर असं वाटतं की ह्याने मग पेटंट करू नये आणि मलाही करायचं नाही, तर तुम्ही नुसतं पेपर पब्लिश केलं तरी काम होते. त्याच्यासाठी समाधान कशाला करतात. पेपर पब्लिश करा, ब्लॉग लिहा, पेपर नाही पब्लिश नाही ना, न्यूजपेपर असेल काहीच नाही. त्याच्यासाठी समाधान कशाला करायचं. बरोबर. ओके, क्लिअर. Mere use of a non-process machine apparatus unless such non-process results in a new product. ये थोड़ा मैं explain करते हैं. तो आप तुम्हारा confusion रहता है. You are all examiner now. I am giving you example. Suppose there is one machine. Take tobacco the machine. Real case. The machine में एक plate है. All your example. एक plate machine है. Plate है. 30 वर्ष में मशीन वापरते. 30 वर्ष. एक दिवस अचानक मला कळलं अरे ही प्लेट अशी ठेवण्यापेक्षा स्टॉप कीपिंग दिस प्लेट लाईक दिस आय शुड टेक इट इन 45 minutes. Effect is like that, my production efficiency. Like, but what happened? Late was in this way. I just created it in 45. Your examiner, you tell me you will give patent for this. I find the patent. I find it is in your hand for examination. Whether you will give patent to me or not. It is a patent and very good examples. Those were granting patent. 1, 2, only 2, 3, 4, 5.
I will check with operators of similar machinery. And we would have already, but think of it and again. The better if it is operator, the operator.
Nowadays, it is very clear. Nobody have done it.
Simple example again. Step by step in the some. Even what is there? The subject slip plate horizontal. That is more information. दोघां क्षेत्र
म्हणजे 5 जण examiner असं म्हणतात की I will give patent for this remaining all are not related. Right? Those 5 are correct because that improvement is. The last sentence is something. Mere use of a known process or machine or apparatus, unless such known process results in a new product or implies at least one new reactant, that is one thing. Efficiency. Efficiency is increased. तर efficiency जर 50% जास्त झाली 50% पेक्षा जास्त झाली तर पेटंट मिळत असो डोंट गेट द इम्प्रेशन की काहीतरी फॉर्म्युलेशन आहे ऑलरेडी आहे आणि मी ते फॉर्म्युलेशन इम्प्रूव्ह केल्यानंतर त्याच्यामध्ये 10% म्हणजे 50% पेक्षा जर ती कॉस्ट कमी होत असेल तर नक्की यू शुड गो फॉर पेटंट इवन दॅन mere addiction not patentable. Arrangement, rearrangement is not patentable. I can give you example. Conviction. Water plus oil को mix होणारच नाही माहिती आहे किंवा शुगर आणि हे मिक्स होणार माहिती आहे म्हणजे मिक्स करून काहीतरी नवीन व्हायला पाहिजे सिनर्जेटिक इफेक्ट पाहिजे if there is a synergetic effect then it can be patentable otherwise it is addiction a plus a 2a नहीं a plus a square correctly व्हायला पाहिजे geometrically it should improve then it is patentable otherwise it is not आणि अरेंजमेंट रिअरेंजमेंट और डुप्लिकेशन इज नॉट म्हणजे माझ्याकडे 3 मशीन्स आहेत एबीसी आणि 3 मशीन्स आहेत एकत्र काम करत आहेत इफ आय रिप्लेस बी सिक्वेन्स एबीसी आहे आणि बी सी ए बी असा सिक्वेन्स केला दॅट इज नॉट
एक्झिस्टिंग प्रोसेस केस प्रॉफिट आहे एक्झिस्टिंग कॉस्ट केस प्रॉफिट मध्ये मशीन वापरतो पुढे त्याच्यामध्ये कॉम्बिनेशन्स आहेत त्यामध्ये एक कॅश the product complaint एक system damage.
No, there are efforts to check and working of it. But only this 3 are in one sequence, I will just change it. त्याच्यावरती आम्ही ऑपोजिशन फाईल केलेलं आणि खूप मोठी फाईल फाईल करणारी फर्म पण होती पेटंट नाही करायचं आणि हेच चाललेलं नाम युसी agricultural methods, horticultural method not patentable. Protection of plant varieties are necessary. Process of medicine, surgery, curative, prophylactic, or other treatment of human being. Process for similar treatment of animals. Render them free of disease or to increase their economic value. Such as steroid injections for the processes that are not patentable in India, they are patentable in US. Economic production मध्ये वापरतात आणि they have their patents also. We don't follow that. Surgery आपण patentable करू शकत नाही, medical process patent करू शकत नाही. Plants, animals in whole or any part thereof, other than microorganisms. Microorganisms patentable है. Thanks to Anand Chakravarti case. Anand Chakravarti सरांची case आहे. तर त्याच्यामुळे. But see now. Microorganism, but including seeds, varieties, species, essential biological processes, propagation of plant, animals, at all not patentable. बिल्कुल नहीं. आणि mathematical business methods, computer programs, algorithm not patentable. Business method patent US मध्ये allowed आहे.
specifically medical, for example, I invented a vaccine, corona vaccine invention.
Vaccine is patented. It is a product. Vaccine is a product.
Every medicine is a product.
Microorganisms नाही, पण seeds patentable नाही. Microorganisms patentable आहे.
But not including पाहिजे ना.
We make the check करते, but seeds varieties of species, essential biological substances, they are not patentable. Okay. फक्त तिथं other than microorganisms, but including outside. US ऑस्ट्रेलियन पेटंट मध्ये अजिबात करायचं त्याला काही नाही ते चेक पण होत नाही नेवर नाही डोंट गो फॉर दॅट इज नॉट ऍक्सेप्टेबल इन इंडिया तुमच्या लँडच्या ह्याच्यामध्ये नाही ऍक्सेप्ट करायचं यू विल बी पेटंट करत असते लँड करत नाही डोंट गो लँड नेर नहीं यूटिलिटी देखो चाइना में है यूएस में है देखो we don't follow utility patent concept in India. So our net ranking and that they will also not consider utility patent. Profile. आणि ऑस्ट्रेलियाचा मध्ये आलेलं होतं तर ते चेक पण करत होतं ते तर करूच नाही बंद झालं ते मला वाटतं पेटंट ऑफिसला पण काहीतरी ऍक्शन घेतली हे आता जनरल आणि कॉपीराइट कसं पेटंटचं मेंटल ऍक्ट आणि हे परत कॉपीराइट मध्ये जाऊ शकतं प्रेझेंटेशन आणि हे कॉपीराइटचं आहे टोपोग्राफी इंटिग्रेटेड सर्किट लेआउट डिझाइन मध्ये ट्रॅडिशनल नॉलेज डिफरंट सब्जेक्ट आहे तर बट ते आर नॉट पेटंटेबल ट्रॅडिशनल नॉलेज हे डिफरंट सब्जेक्ट आहे त्याच्यामध्ये आता बट दॅट इज नॉट पेटंटेबल ठीक आहे ठीक आहे नॉन पेटंटेबल क्लिअर सेक्शन 3 फक्त मी बघते मॅडमकडे पाठवते त्याचे तुमच्याकडे ठेवून द्या very important. Now this is very important criteria for patent. Novelty, non-obviousness and industrial applicability. Industrial applicability we can easily judge. Because that's an industry use आणि का नाही आपण लगेच कळतो. Novelty आम्ही patent search करून आणि research paper आणि हे सगळं search करून सांगू शकतो. आहे की नाही पण त्याला एक्सपर्टच पाहिजे. तुम्ही करत नसाल तर तुम्ही गडबड करता. एक्सपर्टली केलं तर ते व्यवस्थित मला मिळणार तरच नॉवेल्टी आहे आणि मधलं काय नॉन ऑब्वियसली तो थोडा ग्रे एरिया येतो त्याची टेस्ट अशी आहे की one is a mechanical engineer and he does something then another mechanical engineer should not feel that हे मला पण आलं असतं हे काय केलं that his reaction should not be like that his reaction is मला कसं कळलं मला कसं कळलं ठीक आहे सो ती रिएक्शन येणार सो why I not follow हा क्वेश्चन जर आला तर ते नॉन ऑब्वियस फिलॅमेंटीचं नाहीच होतं बल्बचं किती 1000 टाइम्स दे हॅव ट्राइड आणि मग ते कन्स्ट्रक्शन फिलॅमेंट ही पेटंटची टाइम आहे तर प्रोव्हिजनल पेटंट आणि कंप्लीट पेटंट असं एक ऍप्लिकेशन दिसतं तर मी तुम्हाला डायरेक्टली सांगते की डिस्कशन पण जनरली तर प्रोव्हिजनल कन्सेप्ट काय आहे की तुमच्या डोक्यात कॉन्फिडन्स आला की हे माझं काम आहे मी नेक्स्ट 12 महिन्यात कम्प्लीट करू शकतो आणि हे पेटंटेबलच्या तिन्ही क्रायटेरिया फॉलो करते नॉवेल्टी नॉन नॉवेल्टी हे जर तुम्हाला फिक्स डोक्यात आलं त्या दिवशी प्रोव्हिजनल पाहिजे कारण प्रोव्हिजनल वरती तुम्ही प्रायोरिटी सिक्युअर करा पण तुम्हीच नाही ना फक्त करत आहे रिसर्च जगामध्ये सगळे रिसर्च चालतात नोबेल प्राइज पण म्हणून डिवाइड मध्ये द्यायला लागतं बिकॉज ॲट द सेम टाइम सेम डिस्कवरीज डन बाय 3 डिफरंट फील्ड क्लासिक जेनेटिक्स पेक्षा बरेच केसेस व्हॉट यू हॅव टू डू प्रायोरिटी सिक्युअर करायसाठी प्रोव्हिजनल करायचं नेक्स्ट 12 months मध्ये मात्र कंप्लीट स्पेसिफिकेशन फाईल झालंच पाहिजे लेटर दे यू आर रिसीव्ड प्रोव्हिजन म्हणजे आली नाही आधीच असतं ते तुमचं काम कंप्लीट झालेलं नसतं पण तुम्हाला कॉन्फिडन्स असतो की बाबा आपण करू शकतो नाही This is very bad. As per me, I always prefer to go for. इवन माझ्याकडे क्लायंट जरी आले कंप्लीट घेऊन तरी मी परमिशन दुसऱ्या दिवशी प्रोव्हिजनल फाईल करून घेते आणि मग निवांत एक महिन्याला तरी चालेल पण माझा एक महिन्यात वाचवला माझ्या क्लायंट्सला एक महिना आधी मी सिक्युअर करून घेतो इश्यू करू शकतो आणि जेव्हा आम्ही सर्च करतो तेव्हा आम्ही तुम्हाला 10 पेटर्न देतो त्याच्यामध्ये पब्लिकेशन नाही करायचं हे प्रोव्हिजनल फायलिंग नाही अर्ली पब्लिकेशन आणि अर्ली एक्झामिनेशन तुम्ही दोन्ही करता नुसतं पब्लिकेशन करत जनरल आणि जर तसं करत असाल तर युअर मिस्टेक जर तुम्हाला एक्झामिनेशन अर्ली पाहिजे तर तुम्ही पब्लिकेशन अर्ली करा तुम्हाला एक्झामिनेशन अर्ली नको तर अर्ली पब्लिकेशन पण करू शकता I never select early examination apply to by default early publication. ते जर 18 महिने झाले असतील तर प्रश्न येते 18 महिने झाले असतील तर ते फाईल करायचं मला एक्स्ट्रा पैसे 2,500 द्यावे लागतात पण ते 2,500 मी म्हणते थांबू नका काही गरज नाही तरी का करायचं 2,500 नाही तो माझा प्रश्न आहे की जर आपल्या एक्झामिनेशन अप्लाय करते पब्लिश होणार नसेल तो पब्लिश होणार चालेल पण तो पब्लिश होणार 18 महिने 18 महिने शिवाय पब्लिश होत नाही पेपर No, you are linking examination and publication together. Publication चा फॉर्म नाही आहे. Examination चा फॉर्म 18 आहे. तुम्ही अर्धी एक्झामिनेशन दिले 4,000 एक्स्ट्रा देता. 4,000 एक्स्ट्रा देता केव्हा देता तुम्ही पब्लिकेशन झाल्यानंतर तुमचं मध्ये कन्सिडर होईल. तुम्हाला आता पब्लिकेशन नाही करायचं त्याच्यात एक्झामिनेशन करूच शकत नाही म्हणून त्यांना तुम्हाला परत 2,500 द्यावे लागतात. म्हणजे तुमचे 2 महिन्यात एका महिन्यात पब्लिश करतात. 6,500 एक्स्ट्रा आणि 6,500 एक्स्ट्रा करून काय करायचं उलट तुम्हाला जेवढं लिहिते होईल तेवढं चांगलं करायला खूप हेडेक लागतो म्हणजे हेडेक होतो करायला तो जितना टाइम यू बाय दैट इज गुड and well protected nobody is watching you if your patent is in public everybody will watch you तुम्ही काहीच करू शकत नाही आणि आपण खूप छोटे प्लेयर आहोत अन्यासाठी तुमचं पण टीएससीचा जवळचा येतोय आणि ते पेटंट दाखवाल म्हणताय मग ते ठीक आहे दॅट यू आर अर्निंग समथिंग बरोबर आहे त्याच्याशिवाय नाही ठीक आहे हे 18 मंथ्स कॉम्प्लिकेशन बाय डिफॉल्ट आहे अच्छा रिक्वेस्ट ऑफ एक्झामिनेशन चेंज झाले आता 31 मंथ्स हे लक्षात ठेवा 31 months पर्यंत एक्झाम रिक्वेस्ट गेलीच पाहिजे आय विल गिव्ह यू टिप ज्या वेळेला कंप्लीट फाईल करतात त्याच वेळेला एक्झामिनेशन रिक्वेस्ट फाईल करायची ती विसरायची नाही ते विसरलं तर तुमचं एक्झामिनेशन होत नाही पेटंट पब्लिक करून म्हणजे कसं आहे युनिव्हर्सिटीला मी ऍडमिशन फी देते पण मी एक्झामला जाताना परत एक्झामिनेशन फी देते तशी फी आहे म्हणजे विसरायचाही प्रश्न नाही आणि दुसरं तुमची क्यू असते ना एक्झामिनेशनची ती त्या एक्झाम फीवर लागते ऍप्लिकेशन नंबरच लागतो म्हणजे माझ्याकडे 31 महिने आणि मी जर 31व्या महिन्यात केलं तर माझी क्यू कधी पुढे जाईल मी जर पहिल्याच महिन्यात दिलं तर माझी क्यू तिथून चालणार मग ते डिपेंड्स तुम्हाला केव्हा पाहिजे फॉर्म नंबर एक्झामिनेशन फॉर्म नाही 18 पब्लिकेशनचं ठीक आहे हे कंटिन्यू लक्षात ठेवा 48 नाही आहे आणि फर्स्ट एक्झाम रिपोर्ट साधारण कसं रेट कमी झाला आहे खूप झाला साधारण आता 2 वर्षामध्ये APR घ्यायला 24 महिन्यात येतो ते 30 पर्यंत करा पण 48च्या जागी 30 म्हणजे वेळ तुमच्याकडे ठेवा पण साधारणपणे आजकाल जर तुम्ही पहिल्या दिवशी पुढे 18 महिन्यामध्ये नाही पब्लिकेशन 0 पासून कॅल्क्युलेट आहे पब्लिकेशन 0 पासून सगळं कॅल्क्युलेशन 0 पासून 54 म्हणजे थोडा वेळ लागायचा APR फर्स्ट एक्झामिनेशन रिपोर्ट म्हणजे काय होतं कशी प्रोसेस सांगते मी की आज मी पेटंट फाईल केलं, आज पेटंट फाईल केल्यानंतर 18 महिन्याने ते पब्लिकेशन, ठीक आहे. त्याच्यासाठी मला पैसे द्यायला नको काही नाही, बाय डिफॉल्ट एक्झामिनेशन साठी मला 4,000 रुपये आणि एक्झाम फायलिंग साठी मला 1,600 रुपये एवढीच fee. 4 महिन्यानंतर जेव्हा एक्झामिनेशन होतं तेव्हा माझ्याकडे फर्स्ट एक्झामिनेशन रिपोर्ट येतो. तर तो जो फर्स्ट एक्झामिनेशन रिपोर्ट आहे तर तो साधारणपणे आजकाल 24 महिन्यामध्ये येतो. 2 वर्षामध्ये आपल्याला येतो, 2 ते 2.5 महिने. तर फर्स्ट एक्झामिनेशन रिपोर्टचं तुम्हाला इमिडिएटली रिप्लाय करायला फर्स्ट एक्झाम रिक्वेस्ट फॉर एक्झामिनेशन त्याच्यानंतर नाही. साधारण तुम्ही जर पेटंट आज फाईल केलं ना आणि त्याच वेळेला जर एक्झामिनेशनची रिक्वेस्ट दिली असेल तर तुम्ही त्या ह्याला बघायचं, वेटिंग पिरियड तिथून बघा. एक्झाम रिक्वेस्ट दिल्यानंतर साधारण 22 ते 24 महिने आणि फर्स्ट एक्झामिनेशन रिपोर्ट म्हणजे तुमचं थोडक्यात पेपर फेक केलं ते रिव्हिजन तुम्ही रिप्लाय करायचं त्याला आणि मग ते तुमचं पेटंट द्यायचं.
And there are 4 offices in India. Four offices equally efficient or it's just
नाही प्रोसेस मध्ये अशी आहे की तुम्ही anywhere you file patent in India, you are filing in any jurisdiction, always go at one place and the distribution is on any of the patent. It's not like a Madras का patent Madras में ही चेक करो, चेन्नई में do चेन्नई चेक करो.
तुम्ही आता स्टेट
हाँ ते फक्त jurisdiction साठी म्हणजे आपल्या सर्व्हिस ऍड्रेस साठी. म्हणजे tomorrow if you want to file a case on patent office, तर मद्रास वाल्यांनी मद्रास हायकोर्ट, म्हणजे चेन्नई वाल्यांनी चेन्नई हायकोर्ट. jurisdiction फक्त वेगळं, बाकी चेन्नई ते इंटरनल jurisdiction. ठीक आहे. सर्व्हिस ऍड्रेस इज व्हेरी इम्पॉर्टंट. ट्रेडमार्क मध्ये jurisdiction ते मुंबईमध्ये असं नाहीये की एरिया का नाहीये पोलीस स्टेशन मध्ये काही काही टेक केस तसे ठीक आहे. आणि मी आता पीसीटी पीसीटी ऍप्लिकेशनचा पीसीटी ही काय सिस्टम आहे?
पीसीटी मध्ये इंडियामध्ये अप्लाय केलं जगामध्ये अप्लाय करायचं त्यासाठी सगळ्यात आधी
नाही म्हणजे पीसीटीची सोय कशी होती? पीसीटी टाइम टेकिंग फक्त ऍक्टिव्हिटी म्हणजे टाइम टेकिंग म्हणजे मला पेटंट आज इंडियामध्ये फाईल केलं तर मला 12 महिने मिळेल. 12 महिन्यामध्ये मला डिसिजन घ्यायला लागतो की मी कुठल्या कुठल्या देशात जायचं. जर मी 12 महिन्यानंतर मला वाटतं की अरे मला युएसला जायचं होतं, मला युरोपमध्ये पेटंट फाईल करायचं होतं, तर यू कॅनॉट डू दॅट बिकॉज 12 मंथ इज अ बिग डील. ठीक आहे. मग पीसीटीने काय केलं की इफ यू फाईल अ पीसीटी इन 12 months यू गेट टोटल 30 months. म्हणजे ओनली तुम्हाला ते 12 महिने मिळत होते त्याच्यापेक्षा 18 महिने जास्त मिळत. सो यू आर गेटिंग टोटल 30 months फॉर फायलिंग दिस. कारण काय होतं एक युएस पेटंट म्हणजे 3 लाख मिनिमम पकडा मिनिमम. मग तसंच युरोपमध्ये आरिकोमध्ये युएस ऑस्ट्रेलियामध्ये तुमच्याकडे 15-20 लाखाचं फंड पाहिजे. आम्ही फाईल केलंय 26 कंट्रीज मध्ये पेटंट फाईल केले बट वी हॅव फाईल पीसीटी फाईल करून मग केले पीसीटी पेटंट कॉर्पोरेशन केली. तर ती इंटरनॅशनल वायको इज जनरल एक बॉडी आहे वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गनायझेशन जेनीवाला इज अ इंटरनॅशनल गव्हर्नमेंटल बॉडी आहे आणि इंटर गव्हर्नमेंटल अरेंजमेंट आहे. and that body will take care of the communication and harmonization of IP all over the world. तर जिनेवाला तुम्ही ते वायको हे जिनेवाला कनेक्टेड ते ऑनलाईन आहे, खूप सोपं आहे पीसीटी फाईल करणं. त्याच्यासाठी काहीही लॉयरची गरज नाही, एजंटची गरज नाही. ते डायरेक्टली तुम्ही फॉर्म हे करून $100 फी आहे ती डायरेक्टली तुमच्या ऑनलाईन जाते, काहीच करायला इतकं सिम्पल आहे ते. नसतं तुम्ही आज गेल्यावरती गुगलवरती पीसीटी फाईल बघा
इंडियन ऑफिसला डायरेक्ट केलं काय
नाही. प्रायोरिटी इंडियन ऑफिस तुम्ही तुमचं पेटंट ऑलरेडी फाईल असतं पेटंट त्यामुळे तुमची प्रायोरिटी तुमची झालेलीच असते, क्लेम झालेली असते. Whenever you file that PCT application, तुम्ही आता समजा आज तुम्ही इथं मुंबई पेटेंट ऑफिस इथं असाल, या प्लेसला महाड, युअर जुरिस्डिक्शन इज मुंबई, तुम्ही पेटेंट फाईल केलं, तुम्हाला 10 महिन्यानंतर तुम्ही पीसीटी फाईल करून ठेवलं, 12 महिने डेट टाइम, त्याच्या आधी पीसीटी फाईल करा, ह्याला निवांत असा. आता तुम्हाला 15व्या महिन्यात वाटतं की मला युएसला फाईल करायचं. हा, मग युएसला फाईल करताना तुम्हाला पीसीटी फाईल केल्यानंतर immediately our patent office will send a certificate to Geneva that yes, this patent is already filed in our patent office. So they endorse that you are clearly even here in our patent. So they will give you that certificate. Accordingly, WIPO examines. आता WIPOचं कसं असतं ह्याच्यामध्ये इथं टाइमलाईन जर बघितले तुम्ही तर 16व्या दिवशी 16व्या महिन्यामध्ये इंटरनॅशनल सर्च रिपोर्ट येतो. म्हणजे पीसीटी फाईल केल्यानंतर whenever you file PCT within 16 months you will get the international search report that will come to your email ID and maybe you have put the PCT file in the 12th month, whatever it may be. Just like publication never misses, 18 months means 18 months. Similarly, international search report at the age of 16 months, your email ID will have the search report from the Bible. That is a 16 months. 18 months में publication है. Okay, international publication. Okay, and then the another examination it is optional. I will not suggest you to go for that. You have to give extra fee for that. Did not to give. Based on international search report, you can modify your patent without changing scope, and then you can file it to the wherever you want. But we have now 13 months and 18 months extra. So you can decide where to file and you have a time to manage your parts. Okay? And 30 months to the national otherwise, no. If you feel that no, I'm okay with only India filing that. Okay. So that is it. Any doubt in this? तेव्हा वेगळं फाईल करायचं. It's very costly. Here, I will just run through slides quickly, so that if you have any doubt, because I could able to finish first slide of the book. I'm just going to do full screen. Okay. I will just quickly just check now. Slideshow. Just take if it doubts. I'm just quickly running. Just see if any doubt. डिझाईन पेटंटचे आपण इंडस्ट्रियल डिझाईन करतो. इंडस्ट्रियल डिझाईन एक्झाम्पल तर we have a separate industrial design. Okay, that design will be put. And you are saying secondly, digital patent is a mere normal patent. This timeline is 8 years. Normal patent हमारा 8 years. 8 years of survey. And this and novelty aspect is there, but invention is not many times unique is obvious. Obviousness is like different. अपना जुगाड़ जो बोलते हैं that type. Procedure हाँ procedure का procedure examination happening the road they are not doing experiment. Like trade secrets reasoning असा आहे की काही trade secret तुम्ही वर्षानुवर्ष ठेवतो. पेटेंट फाईल केले की डिस्क्लोज आहे. अच्छा ते मी strategy business strategy मध्ये विचार करतो की पेटंट दिले की you have to disclose what is the मग ते वाईजली करायला लागते. ट्रेड सिक्रेट मध्ये एक कॉम्प्लिकेट when I used to do practice ना आता परत करायला लागले but it is coming under project IIT तेव्हा मी करायचे तेव्हा मी literally 60,000 घ्यायचे searching के 15,000 and 60,000 contract 10,000 almost 675 but जब मी पहिल्यांदाच काय करायचे की सर्च करून घ्यायचे 15,000 मध्येच मला करायचं हे पेटंट कोणाचा नाही ते होत नसेल तर मी सांगायचे मी नाही असं नाही करायचं की करायचं तो 100% सक्सेस right.
Suppose I have registered a patent. One more person doing it or doing it. You will go for registration. It is same for my student. Whether government will say this is already patented or it will also do patent for that one.
We go first. We say priority is very important. Provisional. The बता था you miss the bus समझा था. ठीक है.
Position का पढ़ाई.
हाँ.
कितनी बड़ा. ये आंसर मतलब बहुत जल्द देंगे. बाद में ये एकदम डालते हैं. ये हेड करते हैं. बेसिक्स को करते हैं. बाद इस तरह की इंडेक्स पॉलिसी. कुछ आंसर आते हैं. और ये भी मतलब 5 मंथ को चेंज मतलब
But the already now this side मग इथे काय बॉटलचे कॅप आहे ना ते 1000 पेक्षा जास्त भेटतो. ते कॅप मध्ये काय केलं होतं तर इनोव्हेशन त्यामुळे फाईलचे तुम्ही किती पण करा but त्यापेक्षा
मेडिकल सर्टिफिकेशन नाही other than medical means that is
तीन क्रायटेरिया फॉलो करायला नॉलेज नॉलेज
it's a very important thing for the
एक फक्त फर्स्ट पार्ट करू शकले आणि त्याकडे सर्चिंगचं पार्ट आहे I'm not correct.
it's start
हे जर एकदा एक झालं मला थोडंसं पेट डॉक्युमेंट दिले तर प्लीज सांगा त्याच्यामध्ये त्या पेटंट डॉक्युमेंट मध्ये इन्व्हेंटर कोणी बनवलं मला इन्व्हेंटर कोण आहे का? त्याचा प्रायर पब्लिकेशन डाटा दिलेला आहे 2006चा. चेक केलं त्याच्या आधीच काही 2005 ते आपल्याला चेक करायचं. ए आणि बी असेल तर ए असेल तर ऍप्लिकेशन स्टेज असते, बी असेल तर सॉफ्टवेअरचा ब्रँच. युएस मध्ये ते कोडिंग आहे. आणि डेट ऑफ पेटंट इज डेट ऑफ ब्रँड. त्या दिवशी ते पेटंट ब्रँड झालं. आता टायटल टायटल 15 वर्ड पेक्षा जास्त नाही. म्हणजे टायटल आहे 15 वर्ड पेक्षा जास्त चालू. ऑल ओव्हर वर्ल्ड, ऑल ओव्हर वर्ल्ड 15 वर्ड्स होते टायटल. ऍबस्ट्रॅक्ट 150 वर्ड्स पेक्षा जास्त नाही पाहिजे. 15 आणि 15 ऍबस्ट्रॅक्ट 150 वर्ड पेक्षा जास्त नाही पाहिजे. टायटल 15 वर्ड पेक्षा जास्त नाही. ठीक आहे. First, whenever you will see, you will get all information about the bibliographic information, abstract, and one drawing. The drawing is there. This drawing is the selection of the inventor or applicant. The applicant something actually diagram also 25 drawings. Shastra check also they also drawing there. Okay. Claim नेहमी शेवटी असतं. न्यू पेजवर जनरली स्टार्ट होतात 5 पर्यंत. आणि क्लेमला लिमिट नाही. 1000 क्लेम पण असू शकतात, 10,000 क्लेम. त्याच्यातलं प्राप्ती त्याला पानांचं काहीही लिमिट नसतं. पेटंटचा काहीतरी पेटंट 1000 पेजेस मध्ये पण करतात. ओके, सो देयर इज नो लिमिट. किती इन्व्हेंटर एका पेटंटचा असू शकतात? 100 असू शकतात. काहीही त्याच्यावरती लिमिट असाही किती असू शकतात, कितीही असू शकतात, त्याच्यावरती काहीही लिमिट नाही. तसं इथं काही नाही. नाही, इथं तसं पेटंट ऑफिसच्या दृष्टीने एकच भेटेल. तुमचे इंटरनली तुम्ही भेटेल काय घेतात. नाही, ते पण पॉलिसी प्रमाणे पण तुम्ही इंटरनली 100 ग्रामांमध्ये ठरवलं ना, 4 जण आहे तर 50% रॉयल्टी तुम्ही जर केलं असेल तर त्याप्रमाणे वो माझ्या केसेस हँडल केलं म्हणून सांगतो. ठीक आहे. आणि मला आणि कधी मी पेटंट वाचताना ऍबस्ट्रॅक्ट वर दिली टायटल नेहमी स्पीकर डायरेक्शन मला सांगायचंच नसतं आम्ही काय इझिली वाचतो. क्लेम वाचायला त्रास होतो. क्लेम काढायला बसून जातो. मी वाचायला सांगते. आणि पेटंट सर्च करायसाठी म्हणून ई स्पेस गुगल पेटंट वापरायचं आणि ई स्पेस त्या दोन महत्वाचे टर्की डाटा दिसतात. हे दोन्ही वापरले. किती स्लाइड क्विकली रन करते एखादा पॉइंट जर तुम्हाला पाहिजे तर ऑलरेडी ऍक्च्युअली 545 चं वर्क झालेलं आहे. Anybody want to give you I don't want to keep you tied up, but I don't want to like go without keeping on. आणि हे काय याच्यामध्ये ऍक्च्युली एक छोटे एक्सरसाइजेस करायचे होते ते तुम्ही घरी करा. टाइप्स ऑफ आयटी इन युअर ऑर्गनायझेशन एक्सरसाइज घरी करून बघा. तर तुमच्या ऑर्गनायझेशन मध्ये कुठले आयटी पॉसिबल आहे ते तुम्ही फक्त विचार करा. पण 7-8 प्रकार माहिती ना. पण हा मला असं वाटतं की तुम्ही जर तुमच्या प्रोजेक्टला अप्लाय केलं तर जस्ट थिंक अबाउट युअर प्रोजेक्ट, रिसर्च प्रोजेक्ट आणि अप्लाय. दुसरा मला एक तुम्हाला एक्सरसाइज द्यायचा होता हा की याची जी रजिस्ट्रेशन प्रोसेस आहे, मला जर हा फ्लॅट रजिस्टर करायचा असेल तर मी काय स्टेप करते ते तुम्ही फक्त लिहून काढा. तुम्हाला लक्षात येईल की सर ते पेटंट फायलिंगची प्रोसिजर घेत आहेत, तर तुम्हाला लक्षात येईल की रजिस्ट्रेशन प्रोसेस मला एवढंच सांगायचं की टँजिबल आणि इंटँजिबल तरी प्रोसेस फार काही फरक नाही. ठीक आहे. पेटंट सर्चिंग आहे त्याचं मला तुम्हाला डिटेल्स की जास्त देता येणार नाही. पण ई-स्पेसनेट बघा, त्याच्यामध्ये 150 मिलियन पेटंट्स पोस्टेड आहेत सर्च आणि ते मी स्किप करते. तिसरा एक एक्सरसाइज करा की 200 वर्ड्स मध्ये तुम्ही राईट तर लिहून काढा. मी जे काही आता प्रोजेक्ट करता येईल ते फर्स्ट पेजेस होते. तुम्हाला मी हे करायचं सेक्शन 3 मध्ये तुमचं पेटंट दिसतंय का बघा. 200 ला करून बघितलं, सेक्शन 3 अप्लाय करून बघा. त्याच्यानंतर नॉवेल्टी, नॉन ऑब्वियसनेस, इंडस्ट्रियल ऍप्लिकेबिलिटी काय म्हणतो इंडिव्हिज्युअल करून बघा तुमची आणि शेअर करू नका तुमचं कॉन्फिडेन्शियल ऑल फॉर युअर ओन. सर्चिंगचा मला एक्सरसाइज घ्यायचा होता. ते सगळे सर्च इंजिन्स आहेत, वेब ऑफ टाइम्स वगैरे. तर तुम्हाला मी सांगितलं तसं ई-स्पेसनेट बघा, गुगल पेटंट करून बघा. जर काही वाटलं तर तुम्हाला मेसेज करा. माझं मेसेज आहे तुमचं थोडं उशीर तरी फक्त मेल रिप्लाय करायला. आणि तुम्हाला हे करायचं असेल म्हणजे हे कोर्सेस आहेत फ्री ते अवेलेबल आहेत, हे तुम्ही बघू शकता. हे मला थोडं एक्सरसाइज क्वेश्चन घ्यायचं होतं. हा बरोबर येतोय का क्वेश्चन? बरं, 12 महिन्याच्या आत पब्लिकेशन 18 महिने बिफोर 12 months she can do that. Yes. काही क्वेश्चन्स आहेत, फॉर्म्स आहेत, कोर्सेस आहेत, 5 कोर्सेस आहेत फ्री अवेलेबल आहेत. मला पेटंटची माहिती पाहिजे असेल तर रोडमॅप मध्ये मिळेल. रोडमॅप मध्ये आहे पेटंट इंट्रोडक्शन टू आयटी. त्याचं रजिस्ट्रेशन अजून चालू आहे. 28 फेब्रुवारीपर्यंत संपणार आहे. त्याला तुम्ही एनरोल करू शकता अजून सुद्धा. एंटरप्रिनरशिप आणि आयटी स्ट्रॅटेजी, ज्याला एंटरप्रिनरशिप करायची आहे त्याच्यात डिझाईन केलं. आयटी मॅनेजमेंट, तुम्ही IPOSC चे मेंबर असाल किंवा IPR चेअरमॅन म्हणजे असाल, आयटी मॅनेजमेंट करायचे असेल तुमच्या ह्याची, तर तुम्हाला तो कोर्स फायद्याचा आहे आयटी मॅनेजमेंट. आणि आयपी डिस्प्यूट मध्ये चोरी होतात ना, प्रोजेक्ट चोरी झाला, माझा पेपर चोरी झाला, माझं पेटंट चोरी झालं, तर ते ऍक्शन कशा घ्यायच्या की आयपी डिस्प्यूट. आयपी एक्सपर्ट
Courses taking next.
FDP excellent. All FDP. YouTube पर ही माझ्या माहिती प्रमाणे सर्टिफिकेट साठी तुम्हाला पे करायला लागते. पूर्ण म्हणजे इन्व्हेंटरचा प्रोसेस तुम्हाला स्वतः प्रोफेशनल पाहिजे. You should not depend on the college. ते खूप पैसे घेतात. दोन गोष्टींसाठी तुम्हाला लॉयरचे क्लेम करावी ते तुम्ही करून देईल ते सुद्धा करणार रिपीटेड सर्च तुम्ही करता सर्च केलं आणि पॉझिटिव्ह आलं तर ते तुमचं तुम्ही प्रोफेशनल फाईल करा आणि नंतर फक्त बार्गेनिंग करा जेवढा पैसा लागेल no pressure. It's not. And it doesn't get to that. And any US office, they office to me as in mentor to me negotiation.
Legal advisor.
असं काही नाही ते आपली किती असेल थोडंसं बरं पडतं असेल तर ऑब्विसली ती हेअरिंगसाठी वगैरे तुम्ही हेअरिंगला क्रिटिकल असेल बाकी तुमची एक एक्झाम असते ऑल इंडिया लेवल क्वालिफाय झाल्याची पेटंट त्या प्रश्न एक्झामिनरची सर्व्हिस आणि पेटंट एजंट एका पेटंट एजंट म्हणून मॅन्डेटरी ते फायलिंग करायचं असतं. I have passed in 2013 or 2019. People language के mandatory नहीं असं काही म्हणजे लँग्वेज सिंपल दुसरी कशी असते करते किती लीगल टेक्निकल असते टेक्निकल असते काय करतात आणि लँग्वेज क्लेम नाईसली तुम्ही साधे साधे तुमच्याच्यातून करू शकता पण मी म्हणेन की क्लेम नका करू कारण क्लेम आणि सर्च तुम्ही करू आर्टिकल तुम्ही गडबड करा बाकी सगळं तुम्ही बाकी ते तुम्ही 10 पेटंट तुमचे वाचले म्हणून मी ते एक छोटं पेटंट दिलंय ते तुम्ही इझिली वाचू शकता मग तुम्ही तुमच्या सब्जेक्ट नंतर वाचा go for your own subject. If you read 10 patents in your area and whenever you do search report, you give generally at least 5 patents related. Okay. एकदम मी there is. Thank you. Thank you for your patience.
Thank you, ma'am, for such a peaceful session. And thank you for sharing the knowledge about patent facilities in India, intellectual property, intellectual capital, and utility patent, etc. And also making us aware to identify the original product by using the GI tags and explaining the difference between which things are patentable and non-patentable in India. Thank you so much, ma'am. Now I request Professor Chandra Hipre ma'am to give token of love and affection to Gauri.
Thank you.
Thanks for your cooperation. So, moving in a few guidelines I would like to report and notice. This knows that pregnancy is compulsory in the physical program. You need to upload photos also. And your presence in the in this FDP will improve the chances of getting more FDPs, which I